Content 36
I pray for one time. What council is suffering from higher grade on behalf of Mr. Parida. And then so next week we'll work.
Next week we'll do that.
Millard.
Any compliance has to be done.
My petition. The Contracting Council must be knowing that. And must because of his suffering from paralysis.
He is telling well figure, but Your Lordship may kindly note this. Next week Your Lordship will bring. Must be a record. A consent order has not been complied with since the last month. That's why Your Lordship may call
Next week.
Okay.
On the health ground of arguing counsel for the
for the conference. In the meantime, Your Lordship, because there are two contemners. Because at the time the person filed the affidavit, I have made him a party. At the time who suffered the order of Your Lordship, I have. So for the second person, that may be allowed. That petition may be allowed. That
I do not know whether petition has been solved up in him.
We'll do that next week.
That's the strength. Anyway.
Item 2.
It is a matter of 56 days issue, my lord. And already they have taken more than 6 times government taken time. In that connection, I will bring your kind attention to the order, internal page 14.
We are appearing this case. I'm today I have some personal difficulty. I'm out of this, my lord. Can it be Monday or Tuesday? Any day next week?
Madam, next week. Next week.
We are not there.
2 weeks. You are not there, sir.
Madam, this matter relating to regularization, my lord. And the similar matter has been admitted by my lord. Notice has already been issued. So that's why we tagged that.
It is submitted submitted by the counsel appearing for the petitioner. So let the similar matters have already been taken. Point one of them being handy pocket. One of them being the number 39 first one. The same issue emergency notice. You appear.
I'm opening number 1.
Emergency notice. So
I will solve copy man.
Call along with the
My lord.
yes.
Item 4. WBC 792/2026.
For next
2 weeks. Get the request on. Yeah.
Item 5. WBC 9124/2026. Item 5.
None appears for the petitioner. Call of things. What is that? Rectify greetings, etc. Rectify the thing. The petitioner to comply with the order dated 5/5/2026. First call after 2 weeks. Yes. For doing that. Yes.
Item 6. WBC 11435/2026.
May I please, Your Lordship? So here in this case, the petitioner challenged the order passed by the Law Tribunal, which at Annexure 12, the impugned order, my lord. And that petitioner filed one OA application number 12132 of 26, challenging the OP2's procedural irregularities and violation of natural justice, action of the OP2, the disciplinary authority.
What is that order?
That order is Annexure 12, my lord.
No, you get it. What is that order?
That OP2's disciplinary.
What is that? Contents of that order, what are that?
The impugned order, what is that?
Impugned order, Annexure 12, my lord. Annexure 12.
What was that?
Page 48, my lord. Applicant has filed this OA praying for setting aside the inquiry report dated 10/2/26, as the same is based and submitted with material irregularity. As an interim relief, he has prayed that further proceeding based on the impugned inquiry report as submitted by the IO may be stayed till further order of the tribunal or till conclusion of the present OA application. Learned counsel for the respondent submitted that he will be filing counter and objection to the IR in this case, and the OA may be finally heard. The observation, my lord, lastly, since inquiry report has been submitted, we are not inclined to stay the same at this stage, especially in view of the submission of the learned counsel for the respondents that he will be filing counter and objection to the
Inquiry report be challenged.
that inquiry report I challenged before
Can it be challenged?
before the tribunal.
No, how it can be challenged? Inquiry report
As inquiry
on
is
its own, it does not do anything.
my lord.
It goes to the disciplinary authority.
I know.
Copy of the inquiry report will be given to you under Ramjan Khan case. Then you will have your say. Thereafter, the disciplinary authority takes a call on the report. How report can be challenged?
That I am saying, my lord. That is the ground before law tribunal. That I am challenged here also. My lord, kindly have a glance that what are the procedural irregularities and
Report cannot be challenged. Order on report can be challenged.
or that order, my lord. That
Has not come.
what are that procedural irregularities? I am just
No, which order? Which order? Who has passed that order? You are talking of inquiry report only.
OP2 disciplinary authority
Disciplinary authority has passed an order
passed the order.
on the basis of the inquiry report.
No, not inquiry report. Inquiring officer is OP3, my lord.
We know
My lord.
what you are saying. You are saying that inquiry is completed, inquiry report is there.
My lord.
So you have been endorsed with a copy of the inquiry report. Now, before the matter went to this disciplinary authority and an order is passed, you have challenged it.
My lord.
Now, how can you?
Report cannot be challenged.
No.
It's a recommendation.
Now, whatever action taken against me
You
by the
challenge it
by the
otherwise.
OP2, what about action taken?
What action is taken?
Taken that, my lord, I am saying that without following any RB guidelines, RB rules.
But that question arises after inquiry report is acted upon. Inquiry report does not have force, proprio rigor. On its own, it does not operate. Therefore, the best way is, instead of me dismissing with that observation, because OA also will go, you have to file objections to your representation to the inquiry report. Then on that, the disciplinary authority will take call that you can challenge. Suppose a disciplinary authority agrees with your representation. Therefore, it is the first place.
My lord, kindly have a glance. I filed my representation.
Petitioner is not petitioner employee, delinquent employee is invoking the writ jurisdiction of the court for assailing the central administrative tribunals, the central administrative tribunals order stated 10/4/2026, which reads as the next paragraph. Learned counsel for the petitioner submits that the tribunal ought to have stayed the inquiry report that has put in challenge in OA number
132
so I did not stay in the same. An error of great magnitude apparent on the face of the record is perpetrated to the disadvantage of the petitioner himself, and therefore this court should grant the indulgence of the matter. Next one. Any respondents are here? No.
Yes, we are appearing for the opposite party. Yes, sister is there.
Pari, the DSG, appearing shortly, Union submits that ordinarily inquiry report is not challengeable at all, since it is not enforceable proprio vigor. First off, he further submits that it is always open to the employee to submit his representation stroke explanation inquiry report in terms of the decision of the apex court in Ramjan Khan case eventual Supreme Court. Right. So only if an adverse order is made based on the inquiry report, then there will be an actionable plea. We agree with this. Next one. There was some petitions. He is disposed of without interference, requesting the central administrative tribunal to decide the matter at the earliest. It lies in a very narrow compass. First one that is.
My lord, may I submit?
Now, your relief is in the next.
Filed, my lord, one IA for stay.
We have dismissed the petition itself. Even that way should have been dismissed. That is the reason we pending. Yes.
Item 7, WBC 14547/26.
This order will not come in the way of petitioner filing his representation to the inquiry report within a period of 2 weeks. If already not done.
Which has already been asked for. Next Thursday.
Seven is very
Filed already.
already. And
Ah.
seven is
Then
very
the last sentence deleted. Next.
7, WBC 14547/26.
Wait, please, will not speak.
Yes, please.
What's up, the petitioner of this writ application challenges the order passed by the on an industrial tribunal.
Industrial tribunal. What is the order?
The substantial question of law which is involved in this case is whether the
No, what is the
industrial
order?
tribunal they
What
have
is the order?
expanded the scope of reference.
What is the order?
Order is that, my lord. First, may I kindly come to Annexure 12, my lord. Answer 11, my lord. Page 277.
11.
May I place the
This is impediment.
yes, my lord.
How you are agreed with the
Lord, Lord's may.
Are you implemented party?
No.
Then how are you?
What happened, my lord? I've been implemented now by virtue of the order
Correct.
of this honorable tribunal. My lord.
You were heard in the matter.
We are hard in the matter.
Then you have been implemented.
The court, non tribunal, neither has acknowledged, nor has distinguished, nor even has discussed all those points which have been raised.
What is it? The point is 58 Supreme Court.
My lord,
Rajia Begum versus Shah Nawaz Begum.
My lord,
That is
my lord,
this is implemented.
my lord, all those judgments, my lord, was settled in 2019 judgment which has been given by my lord, Honorable Supreme Court. And 2019 judgment, my lord, has categorically stated
There is nothing.
that therein, my lord, whether the scope of reference, my lord, can be.
Commissioner,
Lord's may- Lord's may-
talking the no, taking up not
Lord's may kindly hear me for 2 minutes, my lord.
No, for assailing the order dated 26 to 2026 made by the industry.
Lord's may, I am not a.
The question is not that, Mr. Tripathi. It's
My
like
lord.
it's settled.
My lord,
If you read the O.P. Mallapra's Industrial Disputes
my
Act,
lord, my lord.
at once you will know that.
I have read all the judgments on this point, my
Makes
lord.
no sense because you have been given an opportunity before being implemented, rightly or wrongly. Now you can take up all contentions in your objection to the claim petition. If an award is passed adverse to you, then you can make this order a ground for attacking that order in terms of Order 43, Rule 1, capital A of CPC that are held to be applicable to these proceedings.
When the tribunal has expanded the scope of the terms of
Next.
reference, my lord,
Nothing.
it's a without jurisdiction, my lord.
No. What do you?
CLU industrial.
Order dated 26 February 2026 made by the Central Government Industrial Tribunal, CJIT,
No.
No, my lord. Industrial tribunal.
Industrial Tribunal, whereby petitioner came to be arrayed as one of the opponents to the claim petition filed by the Workers' Union Trade. First up, next one. Learned senior advocate Mr. Tripathi appearing for the counsel on record for the petitioner vehemently argues that the improvement is very bad in as much as the tribunal has not considered the decision cited at the bar and has misapplied the law to the facts of the case as were not by the record. First time, having heard the net counsel for the petitioner and having perused the petition, test of reading, doesn't matter. In as much as, in our considered opinion, broadly, the tribunal has followed the underlying principle laid out by the apex court in Rajia Begum versus Shah Nawaz Begum, AR 1958 Supreme Court. First time, even otherwise, does not have a coherent cause of action. CHOATE. Coherent. Other day, you written something, some coherent cause of action to lay a challenge to the order of the finding as much as it is open to him to make this order one of the grounds for assailing the award if it goes adverse to the interest of, adverse to his interest, as has been provided under under Order 43, Rule 1, capital A, the 1976 Amendment to PC 1908, which is held to be applicable to proceedings of this kind. First, in that connection, all conditions are therefore, in the whole circumstances, petition being weighed up, merits is liable to be rejected immediately according to the needs. First, registry send a copy of this order to the respondent for opinion union immediately. Next.
I was a particular item number 5. I have written that item 7. That is not my case. That is 5. Item 5.
Item number 5.
5. What is my case?
Yes, we have asked for one week time because.
We have given that.
Admission, race admission notice to be increased.
Press admission notice.
Yes, sir.
Issue some rectification. No. That was an order to rectify the pleadings of the.
Rectify the pleadings, sir.
Already pleadings are ready. Yes, it's already rectified. Already rectified.
For the petition.
Then copy should be served then after rectification.
Order dated 5/5/2026 has been complied with. First of registry to verify, and if complied, come up to post the matter for consideration. Okay.
So notice will
Next.
notices.
No. They are registered to verify whether you have done it or not.
Yes, already.
Next.
8 Miller matter is item 4.
Item 4. Same order.
Same order.
This number and you have to print this number, not the Next.
May I please, Your Lordship? Right, the petitioner is a landless lady and a below poverty line person. She has availed one agriculture loan for establishment of a poultry farm. Poultry farm. And she has become defaulted only because the 50% subsidy was not provided in time. The loan was taken way back in 2014.
Because for grant of subsidy, bank is a partner. Bank is not a partner.
Not a partner.
How you will find?
Then, my lord, there is a financial headwinds I am explaining, my lord. Just because of this,
The amount taken?
that amount is 11,86,000.
As on today, how much?
As on today, my lord, as per the last notice, as for dated 7/4/2026. As on 23rd December 2025, 28,82,627 23 paisa.
28, 82, 6.
Around 29. Because it is April. Now from April to May and May to June of life. Is it? June is coming to an end.
So might have been.
So that will be around 29 then. So you have not paid even one single installment.
We have the subsidy amount is deposited.
We are asking.
Two,
Going
3
with simple
installments.
arithmetics, which we have been taught in 3rd standard. We feel you have not paid one single installment.
We have paid some amount.
How much?
That exact amount, my lord.
You have not mentioned anything in the
No.
How petition should
Not
be
because
done?
since we asked the entire details of the bank account, they did not provide us.
You don't know how much you have paid.
Receiver, please. Have you read the
86,000, my lord, 86,000 some odd amount they have
Have you
paid.
read the Moga's pleadings? See Moga's pleadings, law of pleadings.
My lord.
You have not read.
No, I have not read.
Then you have done a mistake. Unless you read the best of the pleadings, law on pleading, how will you be able to draft the petition? Moga's pleadings, you have to read Banerjee's plain, what is his plain? So here written one book only.
Book called Banerjee.
Huh?
I have that book. Banerjee.
But
2 volumes.
bring somebody to read that book.
I'm sorry, my lord. But my ground of challenge is something different.
What is
The lands are agricultural land and sole homestead land. They are exempted under Surface Act
But you furnished that land by way of security.
by way of security. And that land also doesn't belongs to this lady.
Huh?
This is a lease land.
That's all right. The lease also a property. It can be given by way of security, but that security will dissolve on the expiry of on the determination of the lease or eclipse of the lease period. You have no case. You take chance with some other next. Huh?
My lord, the petitioner will deposit some amount.
How much? How much?
10%, my lord.
10%. 10% is not sufficient for eating even one pav. You deposit 30%.
30% will be too high for a below poverty line person, my
But
lord.
then why did you borrow? Why poor person went to the bank with intent to become rich and he wants to make the bank poorer? No, that law will not be agreed. You have given that property. They have proceed against the property. Will you pay 30%?
30% will be little bit.
Then we'll dismiss the matter.
No, my lord, some breathing space may be given to give the 30%.
That breathing time will give you, provided that you pay in 3 installments. First installment should be done within 1 week.
Obliged.
Right. Challenge by the borrower is to the coercive proceedings of recovery, comma, the present outstanding amount approximating to rupees 29, comma, the principal having been taken in a sum of rupees 11,86,000 long ago. First time. Learned counsel for the petitioner submit that his client had some difficulty in as much as the jurisdictional authority did not favor the claim for the grant of subsidy, and therefore she was not able to repay the loans in time. First time, he further submits that she is ready and willing to pay some reasonable amount to show the bona fide, and that she will be hopefully paying the entire money back with interest accruing due if reasonable period is granted. First time. Next time, having heard the net counsel for the petitioner and having perused the petition papers, we are convinced that the prima facie case is made out for issuance of emergent notice and also some reprieve subject to the following condition. 1. Petitioner shall pay 30% of the outstanding amount in the 3 equalized weekly, fortnightly installment salaries. 1. 20%, 10%, 10, make it 10% each. Okay? 10% fortnightly. Very rich. Not only the petition, the interim order stands vacated on its own, but the petition itself runs the risk of rejection. Within totally 6 weeks given, within 2 weeks you have to pay 10%, then the next 2 weeks, another 10%, and the remainder in the remaining 2 weeks. All right? If you do not do, stay order goes. And petition also may be dismissed. All right.
You can take WC 1647 of 2016.
My lord, here I have challenged the order passed by the Central and City Tribunal. My lord, while the petitioner was functioning as branch postmaster, that is extra departmental
EDA.
My lord,
Departmental agent.
yes. He has misappropriated some money. Depositor gives, my lord, money 65,000. That I have also deposited. They have admitted in counter that a default amount which was against me, my lord, I have already made the deposit.
When misappropriated and when paid? You that you.
My lord, immediately during inquiry, I have
No,
paid.
when you had pocketed that money.
My lord, may kindly,
We are asking, kindly do not say, see this page, that page, etc.
No,
We are asking, on which date you were found to have misappropriated the money? And when you know,
In different dates.
2012.
on various
Different-
occasions.
Different.
Four article of charges were framed against me. Same thing. He had not deposited his in the accounts. My lord, during 2012 and 2013. That's my lord, that is the that is
Person, you have seen the apex court decision. I forgot name of the case,
My lord.
where the conductor has taken only 2 rupees out of the collections,
my lord.
and he was dismissed. Apex court upheld that order.
The loss of confidence.
Ah, It's a pecuniary matter.
My lord, only my ground of,
If the thief says, I have given back the stolen article, whether theft comes to an end.
yes, that's right.
See,
But my lord,
how to believe that
only the punishment is disproportionate to the charges. My lord, that this is my
removal?
removal.
What is this? What should he should be had in the office?
Reported to a court, my lord.
He will again do the same thing.
No, if he will be appointed as delivery agent, he will go and give the
Confidence. It's
my lord.
creation of.
However, my lord, I have been put under suspension, thereafter removed since more than 12 years. So, my lord, I have got the punishment in the meanwhile.
Correct.
I am a poor man, my lord.
Yeah.
The lordship may consider my case because on a faith, my lord, my senior superintendent, my immediate authority, he advised me, you deposit so that no action will be taken against you.
Okay.
So, my lord, I have already deposited the amount, my lord.
That amounts to admission.
Yes, that amounts to admission.
If you have admitted,
My lord.
then very the question of inquiry also need not be taken. They have done the right. Okay. Petitioner, an extra departmental agent, while handling the money of the Indian government, had temporarily misappropriated a part of the same on 4 occasions. First of all, in that connection, a disciplinary inquiry having been constituted, culminated into an order of removal on the approval guilt, which again is admitted as well. First off, the challenge being laid at the hands of the administrative tribunal cutter in OA number 194 of 2021, the same came to be negative. First off, aggrieved thereby the petitioner is not here. The door from the court. Next one. Having heard learned counsel appearing for the parties and having perused the petition papers, so he declined indulgence in the matter in as much as the petitioner admittedly remitted back the temporarily misappropriated money. Even otherwise, the proceeding has been, disciplinary proceedings has been held, and the punishment of dismissal or removal? Removal has been awarded. First off, removal simply does not come in the way of petitioner gaining entry to the open market again if he so desires. First off. Next one. It hardly needs to be stated that an official handling the public money has to have absolute integrity, and that morality is not punctus or punctilio of the marketplace. First, if the confidence is shaken of the employer, that would be a sufficient ground for dismissal, removal, if not dismissal. This view is consistent with the category of decisions of the apex court in that case. Take out that judgment in science. First, in the Orissa, that the tribunal has structured its decision with inarticulate reminds of this kind. First, in the Orissa, shall be void of and it's liable to be dismissed, and accordingly it is, courts having been very easy. Okay. Next. Yes.
Well, this is the writ application is not against the full bench decision of the Central Administrative Tribunal.
Full bench decision.
Full bench decision, because there was divergent opinion between 2 members, madam.
It was the third member.
Third member. And third member had delivered the judgment, madam. Annexure 1 is
The foundational facts of the case.
foundation fact, madam, is a case of seeking regularization.
Regularization. How
Yes,
many years of
by casual employee, madam. Our case, madam, they entered into service, madam. They were taken as casual employee, casual laborer, madam, from 91 to 97. Thereafter, no appointment order was issued. They were never engaged by the department directly.
So only from 91 to 97.
Yes, madam.
Thereafter, they have not been engaged.
They have not been engaged by the department, madam.
What is your right to be engaged?
No, I am for the department, madam.
You are for the department.
Yes, madam.
Yeah, now,
And what has happened, madam, the honorables, the division, the larger bench, madam, considered all the judgments based on the recent judgment of Jagos, Sirpal, Yes, but they have not considered one aspect, my lord, because the long-standing continuous, my lord, is the guiding factor. Here, my lord, that is absent.
When he approached a way, find a way.
Before that, my lord, their union approached the labor court. That was dismissed in 2012. Thereafter, my lord, they approached the tribunal in 2015.
No, for the first time they went to tribunal in 2012.
Yes, sir.
There itself, there was 5-year delay.
No, the speaking out was passed, my lord, in...
Is it a reference under 11?
that was, my lord, no, section, I think, my lord, it was 2A.
2A. So removal.
Removal.
This case of kind of retention.
Yes. And that was against them, my lord. But however, they have approached the tribunal and there was divergent opinion, my lord, and based on this principle, my lord, the judgment was delivered. My sole grievance, my lord, that
Appeals for the employee. Yes, it requires consideration. Because two members of the tribunal disagreed with each other. Matter was referred to the other member, one member.
No.
3 judges.
Full bench.
Full bench.
Three members.
Three.
They have heard
It's 2:1.
Pardon?
2:1 or
No. Only even
This is
in
unanimous.
decision by the larger bench, they have decided in my favor, in our favor.
Request
They,
deeper
my
consideration.
lord, subject to 3 lines.
Yes.
My lord, these persons have been continuing since 92 till date.
Till date?
Initially, yes.
Is it
That is
true?
their admission.
No.
What? Allow me.
Show that.
Yes, their admission is, yes.
Show that.
They have stated through outsourcing. Yes, just I am that. They are pleading, they reply before the tribunal also. When I have stated that I have been forced to work under
You
the...
need not talk so much at all.
No, just I
We
am just
come with
taking out this.
information of
Brief,
law.
I have just folded, I am just taking out the brief, that's what I am saying. My lord, I have filed to their counter, I have filed the rejoinder.
We do not know all that.
Yes.
So take us to that sentence where they have admitted that they have been continued till date.
Yes. One line I will read out.
Yes.
At present, they are working under the labor contractors.
Labor contract.
They have shifted us from 2000 up to 2010. We are allowed to continue.
Where is vinculum juris of employer-employee between your client and the department?
And my specific case was that we have been forced to work under the, we have completed 92 to 2010, we are under them. 92 to 95, all these percentages, 24 persons, 23%. 92 to 97, different dates. That is
91 to 97, according to
92
they
to
vary number.
different dates.
Anyway, then it will be still worse for you. Because that will be shorter than the period which you take a computer with 1991 having in mind up to 1997. Anyway, will not dilate much on that now. Question is, where is the employer-employee relationship between your client and the department?
My lord, we all have been allowed to continue under the
Contract.
No. Initially, we have engaged by the BSNL.
You have said that.
Yes,
Even to
and thereafter, all the employees.
Yes.
There was a policy of the BSNL to regularize all these persons who were appointed prior to 1/10/2000. Our case was also recommended for regularization.
You may not follow a threshold now because you should be given opportunity to argue. They
All right.
issue heard alternate counsel appearing for the petitioner. You are panel counsel?
No, I'm engaged.
Alternate counsel seems like so the for the petitioner BSNL on record. Appearing for the counsel for the petitioner on record. First, we have also made a cursory hearing of the counsel for hearing for the respondent OPM. Particularly, the case is made out for deeper consideration. Keeping in view the largely admitted position that these employees were in service on daily wage basis during the period between 1991 and 1997. First off, therefore,
Up to 2010, man. Up to 2000. Initially appointed between 92 to 97,
thereafter,
continued under them 2010.
it is said that it is told at the bar that they were continued on outsourcing basis. Till date. First, if that is so, the question of law rises as to the existence of vinculum juris of employer-employee between the petitioner, BSNL, and OP employees post 1997. First of it merits a deeper examination, as already mentioned. First, in view of the above issue, you appear for all them?
Yes.
This matter is.
Actually, my lord, we stand corrected again. My initial appointment, all these 23 persons between 91 to 97 different date they were engaged. They continued on this under this BSNL till 2010, not 97. Probably no. 2010 onward they met
1997. That is
no. That is probably not.
According to it is 2010.
They have recommended our case for regularization. All these documents are there because my lord is keeping for hearing. I am not saying all these things. So that will effectually
issue.
That's attendance.
First of the employees are represented by Mr. Past. First one. The stay of impugned order till next day of hearing. Yes, it's
Give us an opportunity before passing this
no
interim order, my lord. That
no.
My lord, I am appearing
to
for
get a matter listed also it is too difficult for
No, we
us.
post it the second week of August.
Sir, my lord, I am appearing for the intervener, my lord, on the basing upon that judgment that my case is allowed, my lord. So that's why the department is saying that the case, if it is in view of the judgment, then I may be given an opportunity to say
You are only intervener.
intervener.
Next.
Item 12, WPC 1, 888 of 2026.
May I please, Your Lordship?
Yes.
This against a common order, my lord, in respect of 3 original applications, common order was passed.
Why you went to the tribunal? Why you went to the tribunal?
Seeking the MSCP, my lord. MSCP benefit. MSCP benefits.
That is
Means
Modified SCP, assured carrier progression.
progress.
10 years SCP, then MSCP. Yes.
RSCP and MSCP.
3 applications were filed by the 3 persons. And all 3 applications were heard and disposed of or dismissed in analogous order. This is the one matter. Other 2 matters are yet to be listed. If your lordship will hear this matter or this matter.
No, we'll hear on the 3 matters.
Yes, my lord. Monday or Tuesday, my lord, I am giving the list.
Along with the WPC. So and so. You have also
Yes,
The instruction to appear for the appeal party.
we have noted appearance of Mr. Prasad for UOI. CGC.
Yes, he is appearing with
Tuesday, my lord. Monday or Tuesday. Monday or Tuesday. Pays admission Monday or Tuesday. Problem.
Item 13, 1 of 2025.
The nature of cases, the first judgment has been implemented by them for which they have filed a
Second case, the order of the singular was passed on 3/10/23. They have implemented the very same month, that is 31st/10/2023. Now the writ will file in 2025. I am giving the last one I also submitted.
Implemented means suppose if the defendant pays the decretal amount, is he precluded from challenging the decree?
No. I am
Because under the threat of contempt.
no contempt.
Threat of might not have been filed at all.
Contempt not right.
Therefore, they have complied and have you said that the subject will challenge?
No.
They have not said.
No. I am giving the order.
Right. No.
Have you said while implementing the order, how many days delay?
484 days in my case, second case.
In Dash's case?
more than that, my lord, because
How many days?
484.
No, 405, 484, 329, 330, 323, all are more than 300.
300 days.
the main judgment is, my lord, Rubacharan Naik.
My lords, that is.
Rubacharan Naik is implemented now.
Yes, that
is implemented.
the second case.
And that I am giving the copy.
Leading case is implemented.
Rubacharan Naik, that has been implemented
That is
without.
WPC, Interpol 560.
No,
509.
509.
By citing that.
And also my lord, along with the
Mr. Ben,
My lords, the implementation order is dated
31st 10,
2023. And the order was passed on 3/10/2023.
They have referred.
Order dated
3/10/2023 was implemented on
31 days. Very first they have implemented. And having implemented without reserving a right to challenge. Now, how is that all of a sudden they have woken up and made a challenge to this? Where was the government sleeping?
My lords, in this order, in disposal of order dated this Honorable Court, Miller have been adjudicated 23 for the District of Education Ministry has washed the light of the aforesaid order passed.
At least have you said one sentence that we have implemented this order
Director, my lords,
subject to challenging the same? Show in your appeal memo.
was terminated from service
or without prejudice to your right.
Right.
And that order of the higher authority they have implemented. They have mentioned in the
reinstated and allowed to continue the immediate effect. My lords, since
Regularization.
No.
my lords, they were terminated.
Wrong interpretation.
They were terminated.
They are reinstated.
Without following
How long they were working earlier?
21 years.
97.
My lords, only one thing, there is already a division bench judgment
Say.
which is contrary to this order.
Why
That is, we have annexed.
No, you might have, but you have given your right of challenge. How? What is the? You have not even said that we have implemented the order. Maybe implementer is one department, then legal opinion by another department, preparation of
Yes, ma'am.
by yet another department. There is no coherence in the government. Too many islands in the government, perhaps. Have you said one sentence that you have implemented the order, but still you are entitled to lay challenge to the order for the single judge?
Well, it's in fact the orders, impugned orders, the one relying on one judgment, they have passed the
Correct.
orders.
No, that judgment itself you have implemented.
No.
That judgment was made on 3/10/2023.
Yes, my lord.
We implemented it on 31/10/2023,
Yes.
even before the ink dried.
My lord. That is,
It was also not over.
my lord, no, my lord, that order was passed basing on another order of this honorable
Correct.
court.
That if original order
My lord,
you have implemented. Number one, did you reserve your right, saying that we don't want all headache of contempt jurisdiction because of some judge coming from Karnataka and therefore will implement retake right to challenge?
my lords, we have not waived our right to challenge.
No. Thank you for that. But the question is not that. Did you reserve your right? You have not reserved your right. You have waived your right.
My lords, in fact, in this order, they have stated that prior to 6 months, 3/4/2023, similar matters were considered and relief was granted.
That on that ground, you should have laid a challenge instead of implementing the order of the learned single judge. See the urgency. Wherever government wants, the order is made on 3/10/2023 and implemented on 31/10/2023.
My lord.
Very fast it is really. Government is very, very fast. As fast, as swift as a snake.
Where there is
Wherever they want.
They're teachers.
Regular
Teacher. They have worked.
Going to react.
in fact, they were regularized. What happened? Similar, some persons, they went to tribunal. Tribunal said that this appointment is wrong. After that, government passed order that to implement the order of the tribunal.
Whether they were parties to that way? No. They were not.
Then, my lords, that carried to division bench of this
Division bench upheld the order of the tribunal.
tribunal.
But question is, they were not parties to that at all.
But the issue is the same.
No. These are all individuals. They are not judgments in frame.
That is what single judge has said.
Yeah, he said same thing. He rightly said that. Just give foundational facts.
My lords,
In all these appeal, challenge is to the orders of the learned single judge, whereby the petitions filed by the OP respondent employees having been favored, their removal from service as teachers has been set at naught, coupled with a direction to reinstate them as before, to work as before. First, the lead case was a writ appeal number, writ petition number, na?
writ petition number 11614.
614 of 2023. And the order made therein is in companion appeal, writ appeal number 509 of 2025. First up. Next up. Learned counsel for the learned AGA, Mr. Behura, appearing for the appellant stay, very effectively submits that the order of the learned single judge is contrary to the decision of the Orissa Administrative Tribunal in OA number or application number?
OA number 1090 of 2003.
2003. Decided on?
24/7/2007.
Which came to be affirmed by a coordinate bench of this court in writ appeal number?
Writ petition number 13452
of
2007.
2007, disposed of on
21/4/2010.
21/4/2010.
There, the right of representation has been given.
Right, but it was affirmed.
However, fairly he submits that an opportunity was given to the removed employees in those cases for making a representation, seeking redressal of their grievance. First of all, therefore, he submits that there is error apparent on the face of the record in ignoring the reasoning of the coordinate bench of this court, which had affirmed the order of the tribunal, whereby the teachers concerned were removed from service. First, next one. One sentence there. Learned advocates appearing for the respondent employees resist the petition, making the submission in justification of the order and the reasons on which they are of this structure. Next one, having heard learned counsel for the parties and having perused appeal papers, we decline indulgence in the matter for the following reasons. Number one, the order of the learned single judge in which is that 3/10/2023? In WPC 11614 of 2023 between Dhruva Chandra Nayak.
Dhruva Chandra is written.
Original order is
Chandra is written here.
Original order is
Charan, here it is.
Dhruva Charan Naik versus the state of Odisha and others. What have you written?
And another WPC, Ramesh Chandra.
Another WPC number 11615 of 2023 between Ramesh Chandra Paital versus state and others. State.
And others.
Disposed of by a common order. Dated
3/10/2000.
Wrong. No, this is only one order.
Only one order.
Only one.
Ramesh Chandra is.
They have
Read the
mentioned.
sentence of what you want.
Orissa.
Came to be disposed of on 3/10/2023 in favor of the employees. Correct?
Yes.
Employee consent, in favor of employee consent. That the order has been implemented by the state, by the appellants, by the office order dated 31/10/2023, which reads as next one. Learned advocates appearing for the respondent employees rightly submit that once the state unconditionally implements order of the writ court without reserving the right to lay a challenge to the same, ordinarily, subsequent challenge is not entertainable in view of the doctrine of waiver. First of all, they are also right in pointing out that the implementation of the order has not been pleaded in the appeal memo when the fairness required such a plea. First of all. Next question. The orders in the companion appeals are structured on the basis of the order dated 3/10/2023 made in a Dhrubacharana Nayak case. First of all. Therefore, that order becomes the leading case, which has been followed by the learned single judge on the principle of parity, there being nothing repugnant in the pleadings of the parties. The government, having implemented the order at its sweet will and unconditionally as mentioned above, cannot turn around to call the same in question. First of all, that would virtually amount to blowing hot and cold, which is not ordinarily permissible in a welfare state, as has been discussed by the apex court in Upendranath Hajarika versus State of Assam 2013. First. Even otherwise, we find from the record that all these teachers have already put in more than 2 decades of service with no complaint whatsoever and uninterrupted. First of all, it is not right on the part of the welfare state to abruptly put an end to the services of employees of the kind only on the ground that in some other case, the removal of such employees has been upheld by judicial decisions. First of all, it hardly needs to be stated that in service matters, there is nothing like judgment in rem, all orders being in persona. First of all. In the above circumstances, we also are the learned advocates appearing for the employees notify to us long delay in every matter. The highest number of days being 484 days. In lead case, that is writ appeal number 509 of 2025. First one, we do not find any plausible explanation for the long delay proved. That too, having implemented one of the orders made by the learned single judge, who followed the same for deciding the other cases. In the above circumstances, these appeals being devoid of merits are liable to be rejected, dismissed, both on merits and on delay, coupled with a direction to the appellant state and its officials to implement the impugned orders of the learned single judge within an outer limit of
It has already been implemented.
already not implemented.
Our case,
we are retired in
That's what we have said.
yes, with all consequences of anything. Some were retired
In the
consequences.
it hardly needs to be stated. In the cases wherein the age of retirement has already been attained, the service benefits are to be terminal benefits are to be extended to such retirees. Again, within 8 years. Within the same period. Yes.
Item 14, interception by 9/7/2024.
My lord, I have another in my case, my lord, the employee has not been declared yet. The consequential benefits, well, it doesn't.
No,
It is
we have made two
implemented.
points. One is those who are continuing.
Yes, my lord.
Second part is for those who have already declared. They have made it clear. Yeah.
Please, my lord.
Huh?
My lord, please, my lords. There are
Yes.
two read appeals, my lord. My lord, so can
Two
I-
written.
The second one, fine, please. Here, my lord, I have filed one IA. At the time of filing, due to overlook, the annexures not in proportion. That's why I have filed that application to allow me to file the corrected one which I have filed, that may be accepted. I have
You
filed.
have filed two writ petitions, writ appeals.
Yes, my lord, second one.
The second one is the correct one.
There are two read appeals, my lord. The read appeal, your lordship can have granted
I
IA
in
number.
the very same order.
Yes, my IA number 2429.
Yes.
Yes,
In read appeal number 2794.
my lord. Here, my lord, I have held this IA. There are some paragraph 3, my lord. There are some discrepancies.
No, why two writ appeals?
Yes, my lord, two read appeals.
Why? By the same person,
Two read petitions.
two petitioners.
Yes,
So each one has filed one writ
Yes.
against the same order.
yes,
And the mistake has come up in second.
yes, my lord. The second one.
What was the matter?
My lord, matter, my lord. Originally, the record of right was prepared in name of one Umakanta Panigrahi and Ravindra Panigrahi, my lord. Umakanta Panigrahi, one of the co-server, alienated his person, that is Chocoland. At that time, the fragmentation was not allowed, my lord. By amendment,
Fragmentation was not allowed in the sense, this
consolation.
OCS was not in implementation.
OCS is there, and their permission was not granted to alienate the property by fragmenting the Chocoland.
Oh, from the district magistrate.
Yes, my lord.
Below 1 acre.
Yes, my lord. So,
Less than 1 acre cannot be bifurcated without permission of the
permission is required, my lord. He alienated. And the same was challenged by Sadananda Panigrahi, the husband of the present appellant number 1, before the district collector. District collector allowed the same in my favor. The said order was challenged by the present respondent
That
1.
means what he did.
Means
Said the same.
set aside the salary under section 34 and 35 of OCS and PFL Act.
Oh, there is such a provision
Yes, my lord.
for setting aside the alienation.
Yes, my lord.
the said order was challenged before this Hon'Ble Court.
Just kindly show that.
Which provision giving right to the district collector?
This is the
Read that provision.
yes, madam.
It's a new statute in your state. We don't have.
ओल्ड स्टैट्यूट न्यू स्टैट्यूट में वो उसको उठा दीजिए. I am placing 34 my lord.
Yes.
Application.
So,
Yes,
matter, can we say like this? This matter arises pursuant to order, pursuant to alienation of non-fragmentable land. Correct?
Yes,
That alienation was challenged before the district collector,
yes, madam.
who had set aside the alienation, acting under section 37,
34 and 35.
34, 35.
My lord.
Then that was challenged before whom?
Single
judge.
Yes, in this Hon'Ble Court, my lord. Honorable single judge has set aside the said order and allowed the writ petition.
On what ground?
Two grounds, my lord. I have challenged two grounds. First of all,
Not you. On what ground?
yes,
But
ma'am.
challenge is for the thing.
Yes,
For then what ground the learned single judge?
that is available to my lord as page 47.
No, we are asking you.
Yes, on two grounds that in view of the amended provision, section 36A, 34 and 35 has been go by.
Has been given a go by to 34 and 35.
Yes,
in
ma'am.
view of 36A.
Yes,
What
ma'am.
is 36A?
That repeals 34, 35.
Yes, my lord. And I have challenged that virus here. Because by amending that provision, now the heart and soul of the act has been taken away. That is the Consolidation Act has no meaning, my lord. But 36, 37 are given a checkmate that there is no fragment because the act, very purpose of the act, my lord, to consolidate all the lands so that the farmers will be financially developed. Number one. Number two, they will save their time and the other things, my lord. Now 34, 35 has been repealed.
Repeat.
Yes, my lord, by 36A.
That you are
36.
challenged.
Yes, that also I have challenged. Number, in this writ appeal.
In the writ petition, what was
No, writ petition, my lord, my husband died. I have not been arrayed as a party. The order has been passed. Because I have a right to say, my lord. When my husband was arrayed as a party,
when alienation took place?
yes, your lordship,
Date of alienation.
yes, my lord. That sale deed was executed in the year, my lord, 24/12/2008, my lord.
24/12/2008.
Yes, that is, yes.
When the district collector made the order?
District collector passed the order, my lord. District collector passed the order, my lord, on 8/12/2012, my lord. 8/12/2012, my lord. 28/12/2012.
28/12/2012.
When your client's husband died?
My husband died, my lord.
You can say your client's husband.
So then, the 1/2024, I had my counsel pled to substitute.
We want date of death.
Yes, yes, my lord. Still,
It must be after DC's order.
yes, district magistrate
Which is the
order.
date?
During pendency of the writ petition, my lord,
During the pendency of the petition, he died.
writ petition, before honorable single judge.
LR was not brought on record.
No, my lord.
How it was treated? Nobody reported death.
Yes, yes, my lord. On 31/1/2024, the council, earlier I was not the conducting council, the council who was conducting, he made a prayer to substitute the legal representatives. The said prayer was allowed, but subsequently, on next date, my lord, the order was passed. Because it is the duty of the petitioner, writ petitioner, to bring the last on the record. He didn't bring.
It was not
No,
brought.
man.
They were not brought.
No, man. They are not brought. And the order.
Let us see the past title of the order. Who are the party?
The party is my lord. I am pressing at page 47, my lord. Vijay Samar is the petitioner. The collector is the OP number 1. 2 is Sadananda Panigrai, who is dead. And 3 is Jagondu Panigrai. We are legal heirs of Sadananda Panigrai.
They are made parties.
Sadananda, my husband was there. During penance of the reed petition, he expired.
Correct. They have said dead something, na? Go to the casting. Let us see. No, the cost title of the order.
Cost title of the order, my lord, it is Annexure 2, my lord.
Page
47.
Sadananda Panigrahi.
Yes, my lord.
And
Jagondu Panigrai.
Jagabandhu Panigrahi. Who is your client?
Sadananda Panigrai expired.
Sadananda Panigrahi expired.
My lord.
Whether there was partition in the family?
No, my lord, that was.
Then brother will represent the estate of the deceased under Hindu law. Every co-personal
Yes, my lord.
is the owner of entire property.
Yes.
Till partition takes place.
Yes.
Therefore, there is one co-owner who will represent the estate of the deceased.
That is not the point here, my lord.
That is the point we are telling you.
My lord, here 2 things, my lord. It is when the fact of the death of Sadananda Pranigrai was brought to the notice of the Hon'Ble Court, and the petitioner is the date one to bring their LRSN record. And though Hon'Ble Court has granted time, but next date it was disposed of. Number 1. Number 2, Your Honor. Now, because I was not a party, if I would have been added as a party, I could have challenged that. That the virus of 36A has been.
Judgment order is not binding on.
You are challenging the virus of the act in writ petition, writ appeal.
Yes, ma'am.
How?
Because
that was not before the single judge.
I have no right. I have filed an application, leave application.
File a writ petition, separate writ petition.
My lord, I have filed this writ appeal. I have filed by filing leave application because originally I was not a party. So my leave application will allow. Thereafter, I have a right to file this writ appeal.
No, writ appeal against this order, all right.
My lord.
But that was not the subject matter. Virus of the act was not subject matter.
I filed my lord separate. But I have
separate.
Yes, my lord. I have taken that additional ground. Originally, I will take 5 separate writ petition, my lord. But here, my lord, on these grounds, I have filed.
You take notice, let us.
My lord.
Issue. Let me change Mr. Where I requested Professor Notice for copy number 1, copy number 2, collector. Notice 2, 1 and 3. How many days of delay? You take emergent notice.
My lord.
We consider your application thereafter.
My learning friend is appearing.
You are apparently contesting opposite part respondent 1. And one fact that I think is that as your lordship said that you can represent, that is one part of it, because both the parties filed the petition before the collector together, jointly.
But Apex Court said,
and
even a co-owner, where he dies, his LRs need to be brought on record.
But he was substituted. That part may be wrong. I was just checking up with the lordship soft copy record. I couldn't get it. But my noting so the application for substitution was filed. The council was earlier representing undertook to appear on his behalf for filing a Wakalatnama. I'm not able to get it from the record. I have to verify whether he has filed the Wakalatnama or not. But substitution was allowed. The statement that...
But where is the amendment of the cost title?
No, well, that is true. Your lordship, that is not available in the soft copy. I'll have to check out the hard copy record. But I find an IA was filed.
IA was allowed.
IA was allowed.
Allowed also.
Yes.
Where amendment application is filed, allowed, and the pleadings are not amended within 15 days, that amending order granting leave to amend withers away. by operation of law.
But that I'm not getting. I have to verify. Let my friend also give a copy to
You serve copy.
whatever he has given.
Who is your counsel on record, Mr. Mishra? Whose name we have to read?
He is there.
Madam, so volunteers to appear for OP numbers 1 and 3.
Only one. But B is along with them before the court below. So I'm not.
Pro forma.
Yes, ma'am.
Here is pro forma.
I cannot have
One. Therefore, you will be able to enter these two, number 3 only. Okay. You serve copies?
Yes, madam.
So that in
both the cases.
My lord's permission, only 2 orders of the honorable single judge I will place, my lord. But my lord is submitting that they have been substituted with my lord's permission. Order dated 31/1/2024. IA number 6936 of 21 and WPC number so and so. This matter is taken up. The prayer for substitution of deceased opposite party number 2 is allowed. The consolidated court statement shall be filed within 7 days. IA number is so is disposed of. Next page, my lord. The matter is taken up through another date, 10/4/2024. Release this matter on 7th August 24. No notice has been issued to us and the final order has been passed. This I have downloaded.
I said only substituted. I will check up whether he has appeared or not. I never said that.
No, we have not appeared. That is fine for some.
I never also submitted. I said that.
let us see.
Your lordship may.
But the Article 31 B, small b and c was considered by the apex court in one matter. I don't maybe from Maharashtra, where challenge was laid to the amendment to Prevention of Fragmentation of Agricultural Lands Act in Maharashtra, which has diluted the restriction. This contention was advanced before the Supreme Court. The Supreme Court said, when the act was made, the population was small. Now the population explosion has taken place. Therefore, the land as of necessity have to be fragmented so that everyone will have right to the land. Under Article 31 B and C. Therefore, that also you have to examine. If that contention is already negated by the apex court, then rest of the things will not.
And as it rightly fell from your lordship's side, that he can only challenge it in a writ petition, not in a writ appeal.
Assuming that also, now which he is ready, that point he is ready. That is already decided by the apex court. I don't remember that.
Because it is on change of situation. This Consolidation Act came in 1972. So 2026.
1972, where population of the country was less than 55 crores.
And this amendment has come into force in only 2023.
23. Now 145 crores we are.
Exactly.
If your contention is accepted, then land will remain in the hands of only few, which is contrary to the spirit of Article 31 A and B. Sorry, B and C. The directive principle.
I will examine that, my lord. But my humble submission here by amending 36, I will file separate writ petition. But sir, 36A, my lord. Now the act has no meaning.
One more thing, there is a specific trend here which my Honorable Justice Daskan also must have dealt with, that they transfer, thereafter they file a 3435 for cancellation. This is a trend. And your lordship will in many cases. This is a case of blackmailing. You pay more, otherwise I'll get it cancelled.
Since how long this is happening?
This has been happening since the statute is in vogue.
That was in the year
1972.
70. Now, how many years have elapsed since the act came into force?
45 years.
In the 45 years, what our brother judges have done with matters like this?
Many cases have been dismissed because of the mischief, but this is a trend. That's what I beg to submit.
No, any judicial decision is there on that trend.
Not exactly, but I am saying from my experience of dealing with so many matters on this point exactly.
Primarily, these matters have been taken off in 36, then Board of Revenue, then it has.
Exactly.
Not Article 30, 39 B and C.
And your lordship, those transfers of scheduled caste, scheduled tribe also, same thing. Same kind of trend.
Blackmailing.
Exactly, your lordship.
And they need not pay back the money also.
No, they want more money. If you pay, they will drop the proceeding. If you don't pay, proceeding will go on. There will be a cancellation. You have to run and all those things will go on.
Your Lordship, fix this matter.
No, the service has to happen to OP number 3. Right? Yes, post immediately after service. For case on OP
Your
number
Lordship,
3.
after 15 days, procurement of Department 3 is there because I have taken a lot of pen to list this matter because since last 3 months.
Service, we said immediately after service.
Yes.
If it is not posted or even after service, it is open to the counsel, open to the appellant to move a memo for getting it posted. Okay. Lovely.
There would be a substitution petition pending, my lord, which is 1506 of 2025 for substitution of the appellant number 1, my lord.
Substitution.
Yes, my lord.
Death of appellant number 1.
Appellant number 1, my lord.
Notice is not yet ordered.
No, my lord, it hasn't been admitted as of yet.
Right after filing of the appeal.
Yes, my lord.
After filing of the appeal or after passing of the order?
No, after filing of the appeal, yes.
Application in I number so and so supported by affidavit seeks to bring a lot of the deceased appellant number 1 on record. First, the appellant having died after the filing of the appeal. First, ordinarily such applications are favored by the court in due course, individual course, subject to all just exceptions, into which case of the appellant got place. First, in the above circumstances, in the case favored, leave is accorded to the LR of the deceased appellant number 1 to come on record in the stead of deceased. First, appellant to amend the hostage. You amend the hostage.
Yes, ma'am.
Then it comes. First, immediately after such a
Much obliged.
17, in application 6
May I please? Here the petition of a lordship, the appellant of a lordship, is the management of a special school, not handicapped schools. In his question, the stipulation raised by the government in the resolution, that is Annexure 16.
622. Annexure 16.
Annexure 16. And I read with the judgment of the Honorable Single Judge, where the Honorable Single Judge rejected my application solely on the ground that I have no locus. Where I am challenging, I have no application. I am the secretary of an institution. I am the management.
Secretary of the institution.
Yes, I am the management.
That's be slow. We are not that in.
No, sorry. Sorry, I am extremely sorry.
Whether it's a society.
Society.
Whether there is any resolution by the society enabling the secretary to put the thing in motion.
As per the resolution, as per the society bylaws, the secretary either to sue or be sued. That is the.
No, courts have said, even when that is the test of the bylaw, unless the committee passes a resolution enabling him, only then be sued or suing arises, not otherwise. Then it's correct.
The language says that because you are an
Show the language.
yes, because you are an individual, you have no right.
Yeah, correct it. That means correct. It accords with the decision of long line of the decision of the apex court. In the Societies Registration Act 1912 or something like that.
Oh, sorry, prior to
Central
that.
Act.
Prior to that.
There are citations.
No, here let's see what is the law. Just one line judgment. I am reading.
I have read that.
The petitioner filed the writ application.
We have read that.
It is a
Brother.
resolution in general. It is a resolution.
Tell your
He is my associate.
briefing concept.
No, he is my associate.
We have read it now. You need not read again.
The language says.
We have read, therefore we are telling. That is perfectly in accordance with law.
I do accept my lord.
To sue or be sued.
But with due respect, my lord, the rejection order does not say so, lord. The rejection order says because you are an individual.
No, it's not it. Now we are asking you. Where is your the resolution authorizing you to file the petition?
Well, that I'll file, lord.
Huh?
I'll file.
When?
I'll file, lord. So tomorrow or day after, let's call it.
Well, not at the request of arguing counsel. Yes.
May the prove the version of 2025?
May I present you, on the basis of the departmental proceeding, your lordship, I was removed from service, CISF constable. Now that removed order was challenged, that has been dismissed by the Lord Signature. That is the impugned order, that is Annexure 6, is the impugned order. My submission before your lordship, but if the procedure irregular, your lordship just have a glance.
The inquiry report was in your favor.
My lord, no. My ground that proposed punishment, that is, notice of proposed punishment has not been sought to the delinquent. So he was prejudiced because he could not know whether 1 day salary will be stopped or he will be terminated from service or removed from service. For that reason, your lordship, Lord single judge passed order that no, you show the record where the proposed punishment notice has been issued. Then two occasions time was given, he could not produce this day. And the order is your lordship, that is the impugned order, Annexure 6. So
no, we have the same question now.
Madam.
We have again the same question, which learned single judge had put it to you.
No, not to me, that to
the
other side.
Other side. Other side, your lordship. But that, your lord, this is the issue. So for that, your lordship, my humble submission, I will serve a copy to the Union of India next to only this point and disproportionate punishment. Because your lordship knows that in
what was the charge?
Charges, your lordship, grave misconduct because abusing colleagues and drinking during the period of work.
Sorry.
So now what is the ground?
Ground, your lordship, charge. That is, your lordship, that is, they have finding is that is grave misconduct. For that reason, removal order.
Yes. That's correct.
So your lordship, to see what is the procedure on that point, your lordship.
Let's show that.
That is your lordship.
He abuses the police.
No, it's the colleagues in the, not in the duty, or that is in the cantonment, your lordship.
No, it is not in the premises. Suppose if an employee misbehaves with the conductor in the bus, can he say, no, I had already left the employer's premises.
No,
I am in the bus, therefore.
Your lordship is correct. But my submission is this is the procedure irregularity.
Where is the procedure irregularity?
Your lordship, proposed notice of proposed punishment.
Why it should be given?
Well, that is
the rule says no. Rule says
minor.
If it is a minor penalty,
minor.
It says minor misconduct. Rule says what will be the punishment. If it is a major misconduct, rule says what is the possible punishment. Where is the requirement of issuing notice?
Your lordship, in case of B. Karunakaram case, your lordship knows that
94 Supreme Court. No, that was a different case. It was relating to inquiry report. Which followed 91 Ramjan Khan.
Your lordship, here is also the same. That is, inquiry was conducted. And is the inquiry after your lordship, that is what will be the proposed punishment, that notice has not been.
No, where is the requirement?
That is the requirement, your lordship. Kindly see.
Read.
That is what is the law settled by the supply of inquiry officer's report. Statutory rule denies the report up to the employee.
Where is the report denied? Report is given to you.
But that is proposed punishment.
That does not say. Read your rule. Whether there is a duty to prescribe what is the punishment? No, courts have held against you. I think 42nd Amendment to the Constitution
My lord, 47
dispenses with the
that is 47. That is your lordship's correct. That is 47 amendment.
Yes,
correct.
Second session, what is it?
42nd. Your lordship.
42nd Amendment.
There, even if that amendment, your lordship, for that reason, Honorable Apex Court in the larger bench, that the rule, statutory rule denying this, till then he should be given opportunity.
No, where is your rule saying that punishment, proposed punishment should be made to the delinquent employee? Show that.
Well, I will say it.
No, nothing showing. Now only you have to show. There is nothing, only 1 minute case this is.
Right. Lordship, I'm sorry. Rule, your lordship, that is CISF rule.
Yeah, sure. That's the only point. Otherwise, my dependency will go up.
And another point, your lordship, that is.
No, first point you complete.
What your lordship,
Yeah.
that is.
And is a member of discipline force.
My lord, that is your lordship.
If he only does like this,
Rule 36, sub rule 22.
great.
If the disciplinary authority having regard to its findings on all or any of the articles of charges is of the opinion that any of the minor penalties specified in Rule 34 should be imposed on the enrolled member, it shall, notwithstanding anything contained in the Rule 37, make an order imposing such penalty. Then italic 2. If the disciplinary authority having regard to its finding on all or any of the articles of charges and on the basis of evidence adduced during the course of inquiry is of the opinion that any of the major penalties specified in the Rule 34 should be imposed on the enrolled member, it shall make an order imposing such penalty, and it shall not be necessary to give the enrolled member any opportunity of making representation on penalty proposed to be.
It goes against you.
My lord, that your lordship, that your lord, this is the, even if this is the bar is denied, till then Honorable Apex Court has laid down the law.
Let me read the law. I don't be the apex court.
Paragraph 7. Yes, okay. The lengthy judgment, your lordship.
No, of which year?
Lines.
But your lordship, that hence the incidental question raised above may be answered as follows. Since the denial of the report of the inquiry officer is a denial of reasonable opportunity and a breach of principle of natural justice, it follows that statutory rules, if any, which deny the report to the employee are against the principle of natural justice.
You are reading the ECIL versus Contractual. That does not say that there should be a proposal for punishment.
I'm highly obliged, your lordship.
It is Badruddin. After that, it has come Badruddin. 2019.
And also, that is Ramzan Khan, your lordship. And one more, your lordship, that is about the disproportionate. Punishment is disproportionate because in case of Abar Ali Khan versus Union of India, where that is also CISF constable, what happens in 3 occasions, your lordship, that delinquency. For that one, Supreme Court found that this fellow is not amending or improving himself. So for that reason, the punishment of your lordship amended to compulsory retirement in case of termination. And there, your lordship, that says
What was the misconduct?
Misconduct, your lordship. There misconduct is your lordship. It is allegation of misconduct and misbehavior of the following charges: indiscipline and has learned image on the force, then negligence in duty.
Now, where has he attacked any police? Where did you have the bottle in his hand?
My lord, that is not.
Unlike your client.
But here, your lordship, he has rendered 13 years of service. And your lordship.
You should have been very careful. He is a member of the discipline force. He is not some other FDC.
Sympathy for that compulsory retirement, that may be to compulsory retirement, so that he can get the pension because 14 years can serve.
Delinquent employee who has been dismissed from service on the proven misconduct of the grave nature is assailing a learned single judge's order dated 17/12/2024, whereby his WPC number 1897 of 2013 has been negative. Full stop. In the said, full stop. Learned counsel for the appellant vehemently argued the following 2 points for such assailant. Roman 1 below. The order of punishment of grave nature would not have been handed without giving an opportunity of hearing as to the quantum of punishment, this being the imperative of natural justice. 2. In a more or less similar case, the apex court has downsized the punishment from dismissal to compulsory retirement, and therefore the same thing should be made in this case. First, having heard the counsel for the appellant and having perused the appeal papers, we decline indulgence in the matter for the following reasons. Number 1, which are those rules? Give that rule. Rule so and so of discipline rules, conduct rules.
That is the
CIS conduct rules specifically excludes any opportunity of hearing being given to the delinquent employee for awarding the punishment, once the charges are proved. First off, that rule is not assailed before us. First off, even otherwise, the rule is consistent with the spirit of 42nd Amendment to the Constitution of India, which dispensed with the second show cause notice as to the levy of punishment under Article 311.
Yes.
311.
Was true.
Article, sub-article 311. First, the principles of natural justice are not an unruly horse. First, they are regulated by statute. First, the subject rules have been promulgated under which act?
That is Central Industrial Security Force Act 1968.
CISF Act 1968.
68.
First, where statute operates, the natural principles of natural justice have to yield place. While the apex court decision is Mohinder Singh Gill versus Chief Election Commissioner, AR 1978, SC 851. Next one. The second contention as to the parity of treatment founded on the decision of the apex court in so give that decision. Decision will not come to the aid of the petitioner appellant in as much as the fact matrix of the said case is miles away from that of the appellant here. First one, hardly needs to be stated that a decision is an authority for the proposition that is laid down in a given fact matrix, and not for all that which would logically follow from what has been so laid down. Said the Lord Halsbury in Twin versus Latham, 1901, AC Science. First one. This reasoning having animated the impugned order of the learned single judge, the same becomes inexplicable. First, in view of the above, appeal being thoroughly devoid of merits, is liable to be rejected in limine, and accordingly it is registered to send a copy of this order to the respondent to speak immediately. Next, give your rule book and the decision of the apex court.
Madam.
Then one more note. Learned counsel appearing for the appellant rushed into service the decision of apex court in ECIL versus Karunakar 1994 SC in support of his contention that it is the requirement of principles of natural justice that the disciplinary authority who is acting on the proven misconduct has to give a proposal notice of punishment to have the say of the delinquent. First of all, such a ratio does not emerge from the decision from the said decision. First off, it only said that serving a copy of the inquiry report from the delinquent employee is a must and nothing beyond. This will be number 2. No, number 2. Then, which is that rule copy of yes, rule and decision of the court also. Take that structure vector. Very easy. Yes. Next.
19, is our court
in this case, I was a police constable. Thereafter, I was appointed in 1984. Then allegations were leveled in 2016 that I did not follow the orders of my senior. And in 25th of January of my superior, on 25th of January 2017, they issued a charge memo. And I gave my reply thereafter in 2017 itself. While this proceeding was continuing and is still continuing, in 2019, the superintendent of police passed an order dismissing me from service without any inquiry.
How many years of service you have put in?
From 1984, my lords, that's around 16. 32.
84.
1984, I was up.
Very warm in that.
I was.
How many years of service?
32. 84, so 16.
The charge only charges insubordination.
No, so that's what happened.
No, I'm asking you. We're asking you whether that is the only charge or any other charge was there.
For dismissal, they have considered my past record.
How many years past?
From 2000 and 1996. All of which cases where I've been acquitted or where already disciplinary proceedings have been concluded and minor penalties have been imposed.
Which is the latest punishment?
Latest punishment, my lord, they don't disclose. That is of 2007. And then...
So earlier, there were 3 censure to you.
There were 3 black marks, I explained. And one of them was reversed. But the fact is, the reason they have given for dispensing of inquiry is that I've been absconding since 17th of January 2017. But 25th January 2017, they issue a charge memo to me. I reply to that. They do not proceed with that. It's still pending. The government admits that it is pending prosecution from their counter. And the learned single judge, my lords, fails to appreciate this fact. Learned single judge goes on this aspect that I am aware of that inquiry and thereafter have not participated in the proceedings, which is not true because the 2019 order is based on a separate proceeding. And I have been
heard learned counsel appearing for the appellant issue emergent notice to the respondent. First off, Mr. Devata, on our request, AGA, on our request, accept notice for
all the
matter placed in the Naratham first posted in the 2nd week of August 2026. You copy.
Thank you.
2020, 8.4 for 2025.
Yes.
My lord, this is a case for enhancement of area. That is my homestead. Enhancement of area.
Area.
That is 16 decimal. Actually, it was recorded in the name of my father 16 decimals, but the map is 20 decimals. But in the
how you got that 16 decimal line?
My lord, excuse.
How did you acquire that 16 decimal land? What was the source of acquisition of this 16 decimal?
The source is the single bench has dismissed the case.
No. how your client became owner of 16 decimals?
My lord, my father has filed an objection case. It is in
No, it is your self-acquired property or ancestral property. How did you acquire this?
my father has got it from the in a lease basis from the queen. That is king's property, and my father has got it, and it has been recorded.
Hatpatta.
Yes, my lord, and it has been decided in the civil court, and the civil court has passed order in my favor.
Right.
For how many cents?
For how many area? How much area?
20 decimals. My father claimed
civil court
23
granted decree.
My lord.
Civil court granted decree for 20 decimal.
My
Your
lord,
favor.
civil court has confirmed my ROR because the adjacent plot holder, they have filed a case that I have encroached some area from his land.
So you moved the civil court for declaration of your right title.
My lord.
And it was declared in your favor.
My lord.
In respect to how much area? 20 decimal or how much?
20 decimals.
20 decimal.
So the,
Where is the decree?
My lord, I have not annexed it.
that is the
Only, my lord, only SCO has recorded it to 16 decimals, but my map,
That
where is
comes
the
later.
decree?
my lord, in the WPC,
My lord, in fact, he is challenging the order under review. Review petition was dismissed. He has not annexed the original order which was under review. So nothing in this petition.
original order means my honorable court required the SABIC record on which basis my father has got that 20 decimals.
Question
That
is not
SABIC,
that.
my lord, at that time I failed to submit the previous record because the previous record was 3 acres and 90 decimals. And out of that 3 acres and 90 decimals, my father is entitled to get only 20 decimals.
Where is that?
My lord, that is in Annexure 1 of WPC.
But you have not challenged the original order. You have challenged only the review order.
My lord, I have challenged it before the commissioner. Commissioner rejected my case. So I came in read petition. And a read petition, in that situation, he required the SABIC record. And I argued that SABIC record is not relevant in my case because that was one plot and it is measured 3 acres and 90 decimals. And entitlement is only 20.
You are not catching the point at all. We are not on the same page. We are telling you, your WPC number 19939 of 2017 was dismissed on which date?
On 10/11/2023.
10/11/23.
My lord.
This order you have not challenged in appeal.
My lord, then I filed the review, but erroneously the order of writ petition has not been excused me. I will complain. Only the order I have not annexed.
No, but you have challenged only the review order.
Review, my lord.
Unless you challenge the original order. Challenge to review order falls into insignificant.
My lord, I have not annexed. Sorry, I have not annexed the order.
You have challenged that order also.
Yeah, my lord.
Where is the prayer in your plea? Where are you sought for setting aside the order of the learned single judge? You have not sought for order of the setting aside order of the learned single judge. Even review order is also not challenged. Read the prayer.
It is therefore prayed that your lordship may graciously be pleased to admit the writ appeal, issue notice to the respondents, and after hearing from both the parties, pass an appropriate order
to enhance the area. Where have you put in challenge? The order dated 10/11/2023, whereby your writ petition was negative. You have not challenged the review order also. dismiss this now. Or you withdraw with liberty to challenge that. With this we cannot. It's an appeal. How the appeal should be? Appeal is a complaint against the order of the court below. Therefore, court below's order has to be challenged.
My lord.
51 Supreme Court.
My lord, I pray for.
You withdraw. No question of praying. You withdraw this one. Otherwise, you are dismissing it.
I will withdraw.
Appellant having
And I pray for a liberty to file.
Now seeks leave of the court to withdraw the appeal with liberty to challenge the order dated 10/11/2023 entered in his WPC number. See that one, huh? So and the order dated 20 January 2025, whereby his review WPET number 494 of 2023 has been negative, has been dismissed. In as much as they have not put in challenge in the appeal memo. First one. Next one. Liberty granted and the appeal is disposed of. First. You file appeal against both the orders. Next. Show name. Ah.
21, my lord, it says. It's a state appeal.
20.
Yes, ma'am. Regularization, my lord, has been pleased to stay the impugned order. And the respondent has been noticed.
Party is out of station to accept us.
This first fresh admission it.
Precisely, notice has been
Notice out.
issued and interim order has passed.
You came running like a P.T. Usha. Sit down, sit down. So we'll have it some other day. Call up in 2 weeks.
Item 22. My lord, in this appeal, I'm challenging the order which I've annexed in annexation number 1, my lord. The order of the single judge has dismissed my writ petition with an order stating that the petitioner is permitted to withdraw this writ petition unconditionally.
Yeah.
Lord, my contention here is that it was not supposed to be withdrawn. The learned counsel who was appearing in the court below was requesting for an adjournment. However, it has been withdrawn unconditionally. The order says so. I immediately filed an application. For recalling this order. That has also not been considered.
Considered or rejected?
It has been rejected.
Where is that order?
That is also in page number, it is annexure 6, page number 67. That is also dismissed.
Where is your IA?
Not a copy of the.
What was the modification you had sought for in your application? Did you seek recall of the order or modification of the order?
Recall/modification.
Where is that? There, show us. You appear for the appeal.
Yes, madam. I appear for the
What
respondent.
they want the learned single judge.
Actually, my learned friend was not the counsel before the learned single judge.
That's all right.
But the matter was argued. And after submissions were made, the withdrawal was made.
No,
The matter was argued on merits. And only thereafter.
There should be memo for withdrawal.
Well,
That
At least memo should be there.
very well.
We
So I
want-
am in your lordship's hand.
Therefore, we'll set aside this order. I will restore the WP. I'll let her argue and you also argue there.
Well,
Otherwise, injustice will be costly litigant.
well, I am in your lordship.
This appeal seeks to call, kindly be seated, seeks to call in question the order dated 7/11/2024, whereby appellant's WPC number 24981 of 2024 was dismissed as having been withdrawn unconditionally. First off, the short order is reproduced for ease of reference. That order is this one. Next one. Subsequently, an application in IA number
1666.
was moved seeking recall stroke modification of the said order, and it was supported by an affidavit. First off, however, the single judge was not impressed by the said application, and therefore it also met the same fate. First off, that is how the appeal has arisen before us. Next paragraph. Learned counsel for the appellant vehemently submits that the withdrawal was made in a mistaken notion when there was a worthy cause to press into service. First off, therefore, the application was moved seeking recall of the order, whereby the writ petition was dismissed as withdrawn. First off, that application ought to have been favored, and by that, no prejudice would have been done to anyone, inasmuch as at the most the writ petition would have been restored to the board for being treated on merits after giving opportunity of hearing to all the stakeholders. First, this having not been done, the impugned orders have caused enormous injustice to the appellant, argues the counsel. Next one. Learned counsel Sri so-and-so appearing for the, which respond?
Three and four.
Copy number 1.
Pin number 1 million
Second is appearing for
and 2 and 3 million.
And Sri so-and-so appearing for OP numbers, respond numbers 2 and 3 instead of repeat respond. 2 and 3. Submit, oppose the appeal, contending that once the right to withdraw the list instituted is unconditionally exercised, and the court giving liberty has permitted withdrawal unconditionally, ordinarily, appeal of the kind is not maintainable against orders of the judge. That's the submission. He also tells that, counsel also tells that, appearing for OP numbers 2 and 3, also tells that the counsel who is arguing the appeal now was not the counsel who had appeared before the learned single judge. And what transpired before the learned single judge is a bit different from what has been projected before this court. First one. So contending, they seek dismissal of the appeal. Next, having heard the counsel for the party hearing the appeal paper, this court is inclined to grant indulgence in the matter for the following reasons. Number 1, right to institute a litigation ordinarily includes the right to withdraw the same, while the Shila Parse versus right to correspond Shila Parse. Okay, that is the first concept. However, sometimes in a mistaken notion, petitions are withdrawn, though there are arguable points. First time, when a request is made to recall the order whereby the proceedings were put to an end as having been withdrawn, courts ordinarily would be a bit lenient regarding had to arguable merits in the matter. First, that reasoning is not reflected in the order passed by the learned single judge on the recall application. First off, the order does not mention the word recall at all, and proceeds on an assumption that the prayer is only for modification. Show that where you are using the.
My lord, I do not have a copy of the interim application.
You are required to produce IA.
If your lordship may grant me some time, I'll arrange a copy and also produce.
This appeal having been favored, the orders of the learned single judge are set at law, and as a consequence, the writ petition is restored to the court for being treated on merits, keeping open all contentions of the party.
Obliged.
Government appeal.
23, my lord, it is a state appeal. Can have a glance to Annexure 1 at page 8.
Niranjana Biswal is followed.
Niranjana, only that Niranjana Biswal is
724 days delay.
724 days delay.
723 days.
Now, what is the explanation for the delay proved?
No.
Not that lengthy procedure and.
On this, so what you have got to say?
Merits, my lord, on the first day, even without extending any opportunity or any counter has been filed in this case, keeping in view the state Niranjan Biswal case.
You show that appeal memo, where have you taken up that contention?
My lord, it is at ground number B, my lord. At page 5.
Is it your case that the case does not fit into the parameters of
Niranjan Biswal?
It will not fit into?
No, my lord.
Where have you
Niranjan Biswal, my lord, this is at ground number
Where have you taken up the ground?
Ground number C, my lord.
C. Ground
Yes,
C.
yes, my lord. Yes. Page 5, my lord.
Niranjan was secretary of Gram Panchayat.
Yes.
This is Secretary of Gram Panchayat on the ground of, then it was redesignated as BLW. Regarding this public post or not, on that score, this has been decided. That decision is with me, my lord. I can supply it.
The entire period is counted for the purpose of pension.
Only that much, my lord.
Yes.
Because petitioner was appointed in
On
2014.
Appointed on
2014.
which date?
22 February 2014.
22 February
14, my lord.
2014. As
As junior clerk.
it was a case of regular appointment
Regular.
after selection.
Yes. Prior to that,
As on ad hoc basis since 1990.
in 99,
To 899
on 40.
as on ad hoc basis, my lord.
That ad hoc service to be counted is your case.
Yes, my lord. So for the purpose of pension, minimum pension, my lord.
Years from that was the 1999.
That is around
2014.
15 years. 14 years plus.
15 years.
15 years.
About.
Around 15 years.
How can you discount that? What DS Nakara Apex Court said? It's a service. It will be ad hoc service. But subsequently,
It was 44 days, subsequently extended for another term.
how long?
Twice.
Hold on. This is not a Mughal government. Ours is a welfare state.
But at the time of disposal of the writ application, Mala, we have not been heard, keeping
we
in
are
view that Niranjan Vish.
Very well. We are hearing you now. Argue on merits.
So this is the initial date of joining since 99.
Short
It was for a ad hoc period.
Short question is whether ad hoc service
Can be
of an
counted,
employee who later becomes the regularized
Will-
employee
will be
is
reckoned
to be counted for the purpose of
Pension.
computing the qualifications, qualifying service.
qualifying service.
Settled law. Assuming that this decision is not applicable. Take note. Nothing more. That apart, what is the explanation for the long delay?
Niranjan Vishwas, no, ad-hoc service. Yes, Panchayat Secretary, even it was not a government service, subsequent to that, regularized as BLW in regular service, that period was counted as for the purpose of pension. Entire period was that one was for the purpose of pension.
Yes,
The like job contract 18.6 and 18.3, your lordship's judgment in K.C. Malik judgment, my lord. Day before yesterday also it was there.
it goes against you.
No. Your lordship decided in employees favor.
That's
for minimum pay.
Yes.
Minimum.
So that will be counted in view of the amendment provision of 18.6 of the Odisha pension rules. Here, my lord, we are saying only that stopgap arrangement so far the 44 days, and subsequently.
No, Mr. Monti. See, he gained entry on 2/8/1999.
2/8/99.
Yeah. You should have at least regularized him after 10 years. Going by ML Kesari, Dharam Singh, Jago, etc. You have not done that.
But regular appointment since 2014,
Correct.
he has also been observed in service. It is not disputed.
So this
Of
period,
15 years.
so 9.
What should happen to the 15-year period that we have put in service?
And that has not been taken care or given an opportunity. That is the only sole ground in the writ appeal.
Supreme Court said the pensioners should be treated as a separate class with soft gloves. But you are treating them with hard gloves. The state and its officials are in the Supreme Court appeal to lay a challenge to the disorder dated 16/9/2012, whereby respondent employees WPC number, YAC number 1519 of 2018 have been waived. Essentially, a direction has been given to let on the period of ad hoc service for computing the qualifying service for the purpose of terminal pension and terminal benefits.
Minimum pension that
Minimum pension and terminal benefits. Learned, kindly be seated. Basant. Learned AGA, Mr. Mohanty, firstly contends that the learned single judge was not right in hurriedly granting relief to the respondent employee. And secondly, that the decision in State of Orissa versus Niranjana Biswal 2018 to ILR Cut 2021 was not applicable to case of hand. First. Therefore, according to him, these two infirmities provide a ground for interference of this court in other. First. Since the appeal has been filed after broking a long delay of how many days?
This is 7 to 3.
7 to 3 days. An application in IR number 7 supported by affidavit is moved seeking its condonation. First now. Next. Per contra, the net counsel appearing for the respondent employee resists the appeal both on the grounds of merit and delay. Long group. First, he tells us that although the fact matrix of Niranjana Biswal is not arithmetically accurate, wisdom can be drawn from the decision, even otherwise. First, further he submits that the respondent employee having gained entry to the service on 2/8/1999, came to be made a permanent employee only on 22 February 2014 as junior clerk. First, the long service of nearly 15 years cannot be wiped out without impunity. First off. Next one, having heard the net counsel from the party, having perused sufficient papers we deploy in indulgence matter, broadly agreeing with the submission of the net counsel appearing for the respondent employee. First off. The apex court in T.S. Prakara versus Union of India, 1982.
Yes, sir.
AR 1982. So it's held that the Supreme Court was held that the retired employees has to be treated with humane feelings and soft laws without creating any artificial laws. Only on the ground of nature of service they have put in.
But your lordship laid down the clear law applicable to this case in Krishna Chandra Malik case.
We will say that we will follow Krishna Chandra Malik.
Yes.
You are agreeable with that.
That is the
First. This inarticulate premise having animated the impugned order, comma, the same is inexplicable. First one. Next paragraph. Mr. Panda interjecting the matter submits that in matters of the kind, already the law has been declared by this court in Krishna Chandra, state of Odisha.
State of Orissa versus Krishna Chandra Malik and
State of Orissa versus Krishna Chandra Malik. So give the citation, huh?
Yes, yes.
And therefore, what benefit has been accorded in the said decision to the litigant may be adopted as the measure for this case as well. First, we agree. Next paragraph. The appeal has been filed on a long delay of so many days, and a perusal of the application supported by the affidavit does not convince us that there is a plausible ground, much less explanation for the same. There being a very long delay and there being no proper explanation offered for the same, we are not impressed with the prayer made in the application and therefore reject the application. First up, next paragraph. In the above circumstances, this appeal fails, subject to the condition that the benefit granted in Krishna Chandra Malik shall be the guiding factor for granting the relief to the respondent employee herein. Okay. No.
Krishna Chandra Malik, Krishna Chandra Malik, 17 of 2007, 17 of 2023.
Just
I am handing up.
Yes, good. Just try to.
Yesterday I have given the copy.
Yes.
2018 too, well,
That also I have given.
Yes. Appellants to implement order of the learned single judge within an outer limit of 8 weeks. 8 weeks.
3 months.
Or 3 months. First, otherwise, they run the risk of contempt action. Okay.
Permit to mention my item number 26.
26.
The question of delay limitation, notice has to go. After recess, I will be absent.
Any arguable yes,
Notice has to go to the other side because
no, we'll issue notice provided you convince us. You have to convince us by arguing.
Taken up any other day.
All right. 3, third question. No.
May I please, your lords?
Yes.
My lord, here there is a delay of 1704 days, my lord.
1704 days.
Yes, my lord.
What's the cause for delay?
My lord, first, my lord, we have taken COVID ground and the petitioner, the appellant came to know about the judgment of the learned single judge only in the year 2024.
How? What is the qualification and standing of right?
My client
What does he do?
is a graduate, my lord, is a teacher. He was serving as a Sikha Sayak in Ashram school, my lord.
If he becomes farmer, etc.
Where is the question of COVID? It was in 2022 January. It is January.
My lord, COVID period relaxation by the Hon'Ble Apex Court is March 15, 2022.
It started functioning since 2021. Then partly again sometimes.
Sometimes.
But you have come in 2022.
are there.
The period March 15,
When the order
2022.
was made?
9/1/2020.
9/1/20.
Yes, ma'am.
Filed in 2020.
9/1/20, not even the COVID it was there in Wuhan, in China, not in India. On 19/1, 9/1, it was not there. I think 25 February, January 2020 is the date on which notification has been issued.
Then it is in the month of February.
February.
Yeah.
25.
21st.
तापरे जनता कर्फ्यू ହେଲା।
So there was no COVID when the order was passed.
No, when the order was passed, my lord, there was no COVID in India.
Even thereafter, in 2022 and 23, you filed it in October 2024.
24, yes.
There was relaxation period, it was not available.
Nothing.
That was for 18 months.
That is
Supreme Court has already relaxed.
Period during COVID alone it is extended. On merits, what you have got?
On merits, my lord, the petitioner was initially engaged as Sikha Sayak, my lord. My lord, while he was serving as Sikha Sayak, FIR was lodged by one of the Sebika of that institution. And he was arrested and he was put into custody for 6 days. Thereafter, he was acquitted in the case, my lord. After acquittal, my lord, a disciplinary proceeding was initiated against the appellant. And thereafter, my lord, in disciplinary proceeding, the punishment, as a mark of punishment, petitioner service was dissented.
Offense.
Well, he misbehaved with one of the Sebika and he wrote...
Lady.
Yes, my lord. And he wrote an objection letter to one of the girl student, which is absolutely false, my lord. Nothing has been founded, lordship. Kindly have a glance at the acquittal order.
They will leave it. When the disciplinary inquiry is different, the acquittal is different. Are you pressing into service Ramlal?
No, my lord.
Ramlal will not come.
Ramlal
will not come in.
Not honorably.
No.
Acquittal on the ground
acquittal on the ground of, my lord.
benefit of doubt.
Not in benefit of doubt, my lord. There was...
Complainant did not take proceed.
Yes, ma'am.
That's no problem. Because complainant is always lady. Ladies, they have other problems. Nature itself has placed a
Intervention of the village entry is this.
Village area.
Keeping in view all these aspects, village entries, they intervene in the matter.
And there are some negotiation, but my lord, all these allegations are false allegations.
That's what you are saying. Why? Which lady will falsely make allegation?
Because
They may not succeed in prosecution in another thing.
yes, my lord.
But allegation cannot be had. It fails because quality of evidence is not given. There are lacuna. For these reasons, which lady will come forward and say somebody misbehaved with me? Generally, in Indian society, ladies, women do not come forward. But with this allegation, how to continue as a teacher? The colleagues are not safe at your hand. The students are not safe at your hand. How to continue you?
Well, in India, in our country, my lord, anybody can make an allegation against anyone.
But no, but
My lord, the situation is such.
no. It's a very, very exaggerated version. A student, girl student has made complaint. And a lady colleague has made a complaint.
Yes, my lord.
Such persons will not. You are a liar, you are a...
And my lord, see, we do that.
It's a removal, dismissal.
Yes, my lord.
Take no. Kindly be seated. This appeal, interport appeal by the delinquent employee, delinquent teacher, seeks to call in question a learned single disorder disease 9/1/2020, whereby he is the WTC number 23990 of 2015 has been made. First, in the said writ petition, he had challenged the order dated 22/9/2015 passed by district welfare officer, whereby he was disengaged from the post of Shiksha Sahayak on the ground of his unauthorized absence, misconduct with a lady colleague and a girl student, and also his involvement in a criminal case, although the same ended in acquittal. First class. Next paragraph. The appeal has been filed against the impugned order dated 22/9/2015. When did you file it?
Well, after a delay of 1704 days, my lord.
Against the order dated 9/1/2020.
So you filed it on
9/10/2024.
On 9/10/2024.
Yes.
And thus, there is a long delay of
1704 days.
1,704 days in filing the appeal. First one. An application in IA number so and so supported by affidavit is moved, seeking its condonation. First one, the appellant has pleaded the COVID-19 pandemic as the principal ground for the delay. A perusal of the application does not generate confidence in the mind of the court that what has been averred is bona fide, and even if the averment is taken at face value, would constitute a plausible explanation. Therefore, the application is liable to be rejected. First. Next one. Having heard learned counsel for the parties, next one. Learned counsel for the appellant when we suspects that the criminal case ended in acquittal, and that aspect of the matter has not been noted by the disciplinary authority while awarding the punishment of disengagement. First, according to him, this would constitute an error apparent on the face of the record, which warranted learned single judge to interfere in the matter for setting the same at naught, for setting the injustice at naught. Can we see this expression? Learned AGA Mr. Monti, appearing for the respondents, makes a submission in justification of the impugned order, telling the court that there being absolutely no explanation whatsoever for the long delay proved, the application is liable to be rejected. First, he also tells us that in the light of decision of the apex court in Ramlal versus so and so 2023, perhaps 23. Petitioner, the appellant is not entitled to any leniency in a grave misconduct that has been proved in the disciplinary inquiry, regardless of what has happened to the criminal trial. First, so contending he seeks dismissal of the appeal. Having heard learned counsel from the parties and having perused the appeal papers, we decline interference in the matter, both on merits and not delay, broadly agreeing with the submission made by the learned AGA. First one, the learned single judge have considered all aspects of the matter and only thereafter has denied relief to the delinquent appellant. Next one. The apex court in Ramlal, Supra, has said that unless the criminal case ends in honorable acquittal, the disciplinary proceedings can be held and sustained on the evidentiary material which has been treated in the criminal trial itself. First, it is not the case of appellant that the ratio in wrong law is readily invocable. First of all, the appellant having misbehaved with a lady colleague and a girl student, the punishment awarded in the disciplinary inquiry is legally perfect and it leaves no scope whatsoever for our interference, regardless of some arguable points in the matter. In the above circumstances, this appeal fails both on merits and on guilt. Courts have been made easy. Next.
2025, it has been 6 to 125.
State is.
My lord, it's a state appeal. The crux of the point, my lord, the petitioner joined as a senior lecturer in 18/3/2010, my lord.
No, 23 February 2000.
Yes, ma'am. And the
18/3 was regularized.
regularized.
Yeah.
The regular post was created in 36/2008, my lord.
What was he?
A lecturer.
Lecturer.
A senior lecturer in film and video editing.
Post was created on January 1996.
Post was created in January 1996. The regular advertisement was there. I was selected. After selection, my lord.
How communication should be?
Yes,
January
14/11/1996.
Creation of post.
Creation of post.
14/1/19.
14/11/1996.
11 or 1?
Can say 11. That is the annexure, my lord. That is 14/11.
And you were engaged on?
On 2000, my lord. On
23 March 2000.
23 March.
Because regular advertisement was made.
February.
No, 23 February it is.
Yes, 23. Yes, my lord, that is 23 March. My lord, that is wrong.
And that is, my lord, March.
23.
Exactly. March 2000.
I was regularly selected.
Selection process was undertaken.
Selection process, regular advertisement was made. Selection process was 2 months.
Advertisement dated?
Advertisement
Which was in
1998. That annexure, my lord, that is on 2/7/1998.
Then you were selected.
I was selected.
Selection dated?
Election, my lord, that is, they have selection, my lord, they have selected, my lord, in 2000. 99, my lord, 99, I was called for interview. Then, my lord, selection letter was.
You were called for interview on 31/5/1999. And by order dated 28/2/2000, you were engaged. Yes. 28/2/2000. He was engaged as senior lecturer.
Interview dated?
Interview is 31/5/1999. And what out suitable means from the very day probably they must have.
And, my lord, even though I was.
Whether you were drawing salary in regular pay scale? No.
No.
After regular selection, my lord, but they are appointed on one contractual basis with a consummation.
On contractual basis.
Contractual basis.
On converting the pay scale.
Pay scale my lord, that is 11,000
500 consolidated.
consolidated.
11,500 consolidated. What is the regular pay?
Regular pay, my lord, they have advertisement, my lord, it is 9,350 to 14,500.
Oh, the basic pay was also reduced. 9,000?
9,350 to 14,550.
That was stated in the advertisement.
Yes, but that is annexed to my lord, annexed to the advertisement.
But you were not given that.
I was not given that scale of it.
What is it?
My lord, contractual period, he was working since 23rd March 2002, 18th March 2010.
18/3/2010.
Exactly.
You're right.
Date of advertisement is 14/2, my lord, in the summer. It is at
No, 2798.
Annexed to.
Date of advertisement is 2798.
senior lecture post, Biju Patnaik Institute, kindly have a glance to the annex 12.
Advertisement, there is selection.
There is a selection
And you were
and accordingly joined
pay scale.
on March 2010.
Huh?
Joined in March 2010 in persons to the advertisement and in the selection.
No.
Just my lord, there is a gap, my lord. Just my lord, sir. 30 minutes. That is, the post was created in Departmental Orissa School of Engineering, that is postmates. And the
11/11/96.
96, 14/11/1996. Post was
14/11.
14/11.
the post was created in Bhubananda Orissa School of Engineering.
Bhubananda
Orissa School of Engineering.
Orissa School of Engineering.
Post was created there. I was regular advertisement was where I was selected in 2000. But I was given contractual appointment. The Biju Patnaik Film Institute was created in 2001. In the Bose campus, Biju Patnaik Film Institute. All the post on the Bhubananda Orissa School of Engineering was abolished, and all the post was created on the same day. That is their government counter in 2002. And I was continuing in the contractual service. In 2008, my lords, again they made an advertisement for the 2009. And they have again made an advertisement and directed me to participate in the event. And finding no other, I filed an application for regularization service. Governing body accepted that the open selection was made and they should be regularized, but the government did not agree. And government made an advertisement, and I was selected. Again, I was selected on 18/3/2010. And my entire case is, my lord, that is contractual period from 2000 to 2010. That should be counted for the purpose of pension. Passing upon my lord, Sheila Devi case.
Which case?
Sheila Devi, state of that is my lord, that is subsequently my lord.
State of Himachal Pradesh versus
Sheila Devi. That is my lord, a recent my lord that has been followed by my lord, that is
2023, my lord.
And in the meantime, my lord, I was retired. And my entire case, my lord, the past service should be counted towards for the purpose of pension.
In that contractual service is counted.
No, they have not contracted. They have not counted the contractual service.
No, you have given this.
The Honorable Court directed us. The court directed to count the service for the purpose of pension. That is the last paragraph. For the writ petition's reasons, therefore, the writ application is partly allowed. The opposite party authorities are directed to necessary orders to count the past service rendered by the petitioner from 23 to 2000.
Come to para 9 of that.
Para 9.
Prakash.
In the light of the clear language, Rule 17, here, my lord, in the state, it is Rule 14.
Same.
Parametric provision.
Yeah. Language is same.
Language
almost
number is different.
Almost all same.
Where is that rule?
Yes, ma'am. So,
Rule 14. Counting of service and contract. Nice, you page 36.
Read the language of, let us see the text of that rule here. Rule 14.
Counting of the service on contract, my lord. A person who is initially engaged by the government on a contract basis for a specified period and is subsequently appointed to the same or another post in a temporary or substantive capacity in a pensionable establishment without interruption of duty may opt either
To retain government contribution, to agree to refund of the government, the monetary
fund with interest.
the optional refund shall be communicated with the authority. $17, of which state it was?
Not yet.
It is central service.
This is not central, sir. This is
Central
a,
service pension.
Central service pension rule.
yes, sir.
From Karnataka High Court.
This is AD Jayaprakash is from Karnataka.
Karnataka.
They have taken care of in Sila Devi so far the Himachal Pradesh.
Correct. Rule
That is
70,
Rule 7.
the central rule.
Central.
Pension rule.
We are in 14.
They have employed Rule 14. Or you have copied them.
Either.
Because this is older. Identical. Textual identity is there. That has been interpreted
Yes,
by the apex court.
yes.
Then where is the case for you?
Only the purpose that for that period this was a contractual. By then advertisement was not made. Subsequently advertisement of 2009.
1998.
2009, my lord.
No. 798.
No, my lord. 2009 is the advertisement for the particular post.
No.
Can I have a glance?
Advertisement, see, advertisement answer 2, it is on 30th July 1998 in the paper 2792.
That's one.
And post of senior lecturer is there, sound and TV. 30th July 1998.
This is newspaper.
Well, so far the Biju Patnaik Film and Television Institute is concerned. This advertisement of 2009.
No.
And in but I'm coming, I'm clarifying this. In portions to the said advertisement, petitioner was selected and Annexer 13, he was issued with the offer of appointment on 18th March 2010, Milan.
Correct. Correct.
Am I clear, Milan?
Yes, fully clear. Now we have to make ourselves clear. Now, do you deny that he was in contractual service?
No.
You do not. Then how contractual service should be treated? He is discussed in Rule 17, which is your Rule 14.
Rule 14.
Correct? 17 and 14 are pari materia.
Almost parameter.
Actually identical. Apex Court interpreted Rule 17 and said contractual service needs to be completed. Then how can we exclude?
But this institution, it was created thereafter. Subsequently. But originally, so far the 96 is concerned, that is a separate institution.
Correct. But service is rendered.
Service rendered on contractual basis.
In which institution he renders is irrelevant. The institution where he served, that's also government institution.
Yes, Autonomous Institute of Government of Orissa.
Government of Orissa. How many days of delay?
163 days. Yeah.
There are 163.
Take down. The state and its functionaries have filed this imperative appeal for laying the challenge to take learned single judges order dated 6 September 2024, whereby respondent employs WPC number 13509 of 2011 having favor, in effect, a direction has been issued for counting the contractual period of service, for computing the qualifying period for pension. First, appeal has been filed after booking the delay of 163 days, and an application by number so supported by affidavit accompanies the appeal. First. Next one. Not the DGA appearing for the appellants submits that the contractual period of service between 23/3/2000 and up to
18/3/2010.
18/3/2010 could not have been directed to be computed for the purpose of not have been reckoned for the purpose of computing the period, qualifying period for determination of pension and terminal benefits. Same. First, in support of this submission, he presses into service the provisions of Rule 14 of Orissa Civil Services Pension Rules 1992. For contra, learned counsel appearing for the respondent employee resists the appeal both on merits and on delay, contending that the pari materia Rule 17 of the Central Pension Rules are textually identical. Rule 14 of 1992 rules of the state, semicolon. The same rule, the said rule having been construed by the apex court in S.D. Jayaprakash versus the Union of India, 2025 INSC, INSC 594, has observed that contractual period of service of the kind has to be reckoned. First off, he further submits content that the decision of the learned single judge accords with the ratio of the apex ratio in Jayaprakash, and therefore is inextricable. First off, he also tells us that the explanation offered for the long delay of 163 days proved in filing the appeal has no plausible explanation, has no plausibility, and therefore cannot be accepted. First, so contending, he seeks dismissal of the having heard the counsel for the party that having perused the appeal papers, we decline indulgence in the matter for the following reason. 1. Though an application supported by affidavit is filed seeking condonation of delay of 163 days, no plausible explanation is offered for proving the same. First off, delay cannot be condoned merely because the appellant happens to be the state or its entity. Law of limitation being same for all litigants, subject to just exceptions. First off, therefore, we reject the application for condonation of delay. Next paragraph. We have undertaken to examine the matter on merits as well, since submissions were made by both the sides on the same. First, petitioner, the respondent employee, the post of lecturer, the post of senior lecturer came to be created by the on 14/11/1996 is not in dispute. There was a advertisement dated 2/7/1998, published in the newspaper on 30/7/1998, calling for application from the eligible candidate for the post in question. First off, interview was held on 31/5/1999, and the respondent came to be selected to the post in question in the year 2000. First off, the advertisement specifically stated that the selected candidate would be paid salary in the pay scale of ₹9,350-14,550. First off, that being the petition, the quality and quantum of service rendered by the respondent, even on contractual basis, regardless of consolidated pay, would not be different from that of a regular recruitee. First off, therefore, there is absolutely no justification whatsoever for not reckoning the contractual service for determining the pension and other terminal benefits. First, next point. The reliance on Rule 714 of 1992 rule would not come to the aid of the appellant for the reason that textually identical provision, namely Rule 17 of Central Pension Rules, were construed by the Apex Court in Jayaprakash Supra, holding that even the contractual service of the kind have to be reckoned for the purpose in question. First, at paragraph paragraph 9 of the said ruling, it has been observed as an just by marking it with yellow later. This one. Next one. The Apex Court in D.S. Nakara versus Union of India, 1983, SC so has observed that pension is not a bounty. First off, state being the model employer has to make a provision for the evening of employees on retirement. First off, accordingly, Rule 14 of 1992 rules has been promulgated. First off, when this rule, the text of this rule is identical in all aspects with that of Rule 17 of the Central Rules, there is absolutely no reason for this court to place its own interpretation agreeing with the submission of learned AGA. First of all, despite the vociferous submission, why the principle of pari materia should not be invoked has not been shown. First, in the above circumstances, the appeal being devoid of merits and hit by delay is liable to be dismissed, and accordingly it is costs have been made easy. First, the direction issues to the opponent's hearing to give effect to the improved order of the single judge within 8 weeks, without unnecessarily inviting initiation of contempt proceedings, without avoidably without giving scope for initiation of contempt proceedings. Yes. If my votes also have something.
Item 27, review petition 62 of 2006.
But I'm filing a date chart enabling me to address your lordships.
Have you shared a copy with your friend?
I'm sharing this. In 2000,
Your date chart is thicker than the petition itself.
but has a checkered carrier that I've given in details so that.
What is the issue?
Well, the issue is the
Honorable Supreme Court said
Yes.
one matter, Haryana matter, Himachal Pradesh matter, the date chart should not exceed 2 pages. There is such a judgment.
Yes.
That will be convenient to the court. If your date chart is thicker than the petition itself, what is the fun in having it?
That's my mistake. The order of the learned DR18 was challenged before your lordship in the writ petition. In the writ petition, my lords had issued notice to the
What
present.
happened to DRT?
DRT was yes,
And that was taken in appeal on 17.
70. Appellate court allowed set aside the order, remanded the matter to the DR. There was a delay in filing before the appellate forum.
But 400 quantum of delay.
418 days delay.
In DRT.
DRT.
In DRT.
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 DRT, there was a
In
delay.
filing
Essay.
SC.
That the number?
That is essay number.
Essay diary number 2519 of 2019.
Online of?
2019, man. 2519 of 2019.
This was against what action?
Against the sale.
Auction.
Sale notice.
Auction was on auction notice or auction?
Auction notice.
Auction notice alone. Auction notice dated?
Uh, 24/8/2018.
That was rejected, the essay was rejected on? Therefore, 2 pages.
Yes. My lord, essay was rejected on 29/2/2024.
Appeal was filed on?
My lord, appeal was filed on 8/4/2024.
Appeal number?
My lord, appeal number is 76 of 24.
Filed on?
8/4/2024.
Delay of
418 days.
what is the explanation for delay?
Yes, that is the reason I gave a detail that there were number of writ petitions filed. 2 to 3 rounds we came up again and again. Thereafter, that delay was sought to be explained before the DRT, which the learned DRT did not accept.
No, against order dated 24/8/2018.
Yes.
Were there any writ petitions?
Before that, there were writ.
Before that, what is your fun in having before that?
No, before
So this what happened?
after that, there was no delay.
Then what?
There was no delay.
Earlier, there were so many things happened. Babar had come, Alexander had come, Babar
There
had
was a delay.
these things happened.
Delay between filing of the essay and the notice. There was a delay. That delay was there in the DRT.
In DRT, how many days delay?
418 days delay was considered.
DRT or DRET?
DRT.
DRT.
In filing essay.
Appeal was filed without any delay.
Appeal was filed without any delay.
Oh.
418.
Yes, ma'am. Your Lordship has dealt with the same in order which I am seeking a review. Then
DRT rejected your essay diary
yes,
on the ground of delay alone.
delay and merits
But
also.
merits also.
The appellate court in appeal reversed the finding, saying that it will be reconsidered again by the DRT. Against that appellate order, a writ petition was filed. In the writ petition, notice was sent. I could not appear. My lord disposed of the writ petition, and against that, I am seeking a review. Review.
Your party, you were served with the notice. Why you did not appear?
My lord, he was not well and all, there were things, and there is a delay. My lord, I don't dispute that notice was not sent. It is not a fact. There was notice.
That WP was?
That WP is now, my lord, WPC number 11224 of 2025. Page 60 of the brief.
Disposed of on?
Disposed of on 10/2/2026.
Allowed.
Allowed. It was at the instant of the auction purchase.
There was auction notice. Auction had not taken place.
Auction
You
was,
said auction had not taken place.
no, auction was taken place. The essay was filed against the auction.
Auction notice you said, na?
And subsequently, auction was taken, conducted. It was in my favor.
That remand order was set aside by this court.
Yes.
On?
My lord, 10/2/2026. I filed the review on 24/2/2026.
In time.
In time. And while issuing notice in the review, my lord directed me to pay rupees 10 lakhs. I have complied, your lordship. While your lordship, while allowing the writ petition, as I was not present, the facts which I should have been presenting before your lordship was
Why were you not present? Answer that.
My lord, our notice was there and he was not present.
What is your claim?
My lord, he was not well at that time.
No, what is he? What is he standing in the life?
He was doing business now.
Business he.
My lord, he was doing trading business and all.
How long he has been in the business field?
My lord, since 2010.
Since 2010. Last 15 years he has been, 16 years he has been.
Yes.
Now what is his qualification?
That
that you have to say.
Well, I'll file an.
You are not affidavit. Ask him, call him by over phone and ask him what is his qualification. We will not give time for that. It's a 20 minutes job.
It is not directly my client, so I have been asked by my learned friend.
Who is the advocate on record? Tell him to call his client.
He is not present today.
The advocate on record is not present today. I was engaged subsequently after the interim order was passed by your lordship. Qualification, I do not.
He's
I
a
have-
businessman.
Yes, he's a businessman.
Since last 15, 16 years, he has
Yes,
been in the business.
yes.
Businessmen will have wider exposure. There will be generally street smart in the positive sense. Not some downtrodden community.
No, I don't take that.
Or labor.
No, I'm not saying that. I'm not saying that. It is that what is on the record, I cannot go beyond the record.
Unless one answers why he did not honor the notice of the High Court, then for such persons will not grant indulgence at all. Notice is not served, we can understand. Notice was served, but I was abroad, we can understand. Notice was served, but death happened in the family. That also we understand. There is nothing. We'll be laying down a very dangerous precedent if one does not respond to the court notice. And thereafter, rendering the judgment comes for a review. That will be waste of public time.
That what is there on the record, my lord, it is there. I cannot develop anything more. But the question is, my lord, the facts which your lordship should have could have considered, I will not say should, would have considered, was not placed properly.
What fact?
That there was a letter given by the bank discharging me from liabilities. And subsequently, another notice was given after giving a nil certificate. Another notice was given, there is an outstanding of 27 lakhs something else.
Maybe the first notice was wrong. Therefore, another notice is given.
My lord, the account statement also showed there is a nil balance. That is the reason I am before your lordship.
Where is the account statement?
My lord, I have given. In my counter.
You have given that?
Yes, ma'am. I have made counters.
Sir, it will be in the statement of account.
Here, my lord, two accounts. Then one account is nil and another which has been suppressed by my friend.
No, I have not suppressed. I have given body.
The account statement I have annexed.
My senior should not use such harsh words because I will never suppress before the court.
Not you, petitioner.
Petitioner has also not suppressed, my lord. There
are two accounts.
Yes.
One account statement which you have now produced is a nil account.
Nil account.
But the other account reflects the figures.
Well, that was also cleared. That was also cleared because the sale proceeds in the first account, first sale, it crossed the minimum balance given by the bank. DRT directed to adjust the same in the other account. That they have not adjusted.
How much amount?
27 lakhs, they say.
No, auction took place of the other property.
Yes.
When? For what?
Yes, that they check, that's it, yes.
That auction took place when?
My lord, may kindly see.
When the auction was held, what was the auction price?
My lord, may kindly see serial number 25 in my date chart.
Date can give you. Why you make us to do a lot of gym? We are tired. We are asking you, when the auction was held, what was the auction money?
Yes, ma'am.
Simple. Bank is a scheduled bank or nationalized bank?
No, this is Bank of Baroda, national bank.
Nationalized bank. It undergoes auditing at the hands of the CAG.
Auction was on 7/9/2018.
7/9 or 7/8? 7/9.
7/9.
2018?
80.
Now, what was the auction money? Bid amount?
Bid was 75,14,000.
What was the amount due?
After adjustment, my lord, whatever two statement of account I have annexed, my lord, both are up to calculation up to 2010-2017.
What was the amount due?
Amount,
Outstanding.
that time, my lord, 20 lakhs, 11,698.
So around 50 lakh was in excess and 55 lakh.
Here, but while that submit, we could not able to adjust this thing because so many accounts are running. And so many cases are going, one after another, writ petition is coming, one writ petition is not to deal.
How it is related to accountancy?
Account money, that money, but we cannot because restriction was there from the honorable court. That's all. Right. Yes.
Money should not be appropriated.
My
outstanding amount.
Right. That point of view, adjustment, though, lot of things were there.
Now, if you adjust, how much it will be?
That I am telling that after here by virtue of DRT order, DRT has clarified that if you have got any amount, you adjust any amount.
We are asking you how much amount?
That was 27 lakhs something.
The auction on 7/9/2018 was for 20 lakh order.
20 lakhs, no matter. That
Outstanding.
outstanding was
How much outstanding? Case of simple accountancy. There is one famous book by Professor Glanville Williams, Learning the Law. Small book actually. It was earlier red color, now it is made green color. They learned, he was the Queen's Counsel, great professor who edited Salmon's 11th edition, a great scholar and great criminal lawyer in England, London. He has written that book. He has enlisted as many as 18 subjects which lawyers should study. One of them is accountancy. Unfortunately, I do not see any university prescribing that book as a textbook for the students. Simply recommended reading. One of the best books.
My lord, the auction has been conducted on 24/8/18.
7/9/2018, not?
Sorry, but sale notice was 24/8 and again it is concluded on 7/9.
7/9/2018.
That day, outstanding was, it has been mentioned, annexed by this review petitioner, page 35, but it is in Orissa. That is 30,69,410.
1 second.
30,69,410.
This was outstanding as on?
As on 1st March 2014.
First March
2014. That mentioned in the
understand.
That is maybe that is the NPA date, I think, from the NPA amount. Oh, that has been mentioned while conducting the group.
That will not help you. You held the auction on 7/9/2018.
Right.
So after this, what was the amount due? That you have to say. That amount could have been appropriated, the auction money, and the remainder should go to the other account. This is what DRT said.
DRT has been clarified that the order. Yes,
No, we want to know, after 7/9/2018 auction,
I'm just.
amount was generated 75,14,000.
Kindly see. Mine comes.
Yes, Mr. Bose, according to you, how much money was due?
30,69,410.
As on
Outstanding loan.
2014.
This figure is coming on 24/8/18. No, but he says 132,000 for newspaper, the auction from mayor, self-place, petitioner essential land and building belongs.
As per their
They
statement.
sell that 7,918 for recovery of auction.
This is the date of the was correction. No, due as per bank letter dated 21/10/2007. Your date may not be correct.
21/10/17, my lord.
On what basis you are saying that?
My lord, that is annex page 19 to the writ petition, which my lord said that, friend said that I have suppressed. It is not there. It is on the record.
I beg submission. I know that has been recorded in the DRT order. I don't kindly see. And another thing, my lord, I mean, pointed that based upon whatever communication we have given, DRT has given liberty that you go and approach for OTS. After giving this, that is reflected in the order itself. Page 53 of my counter. There, he has, based upon that, he has filed a OTS proposal also.
In the proposal, how much he has?
He has not quoted anything. That is whole, we could not able to consider the OTS. Based upon our letter,
He should have given offer.
offer has not given, so we could not able to consider, then we proceed. That is the order, both the orders are clear, his letter is also annexed. His OTS proposal, if is made, mine says that, if you have no OTS, you could able to challenge that day. And it is clear, my lord, here it is a page 53 of the.
No, all that circus may not be necessary at all.
Right.
Simple accountancy.
Right.
As on 7/9/2018, or at least say, because it gives up to maximum 90 days, under Rule 8. Maximum 90 days.
3 months.
3 months it is given.
Not
But
executed.
making the payment. Even if it is taken, that will be 5/12/2018. As on 5/12/2018, what was the amount? The due. Outstanding amount. So that amount has to be minus from the auction, because auction money is higher value. The remainder has to be appropriated to the outstanding amount in the other account. As simple as that.
2 accounts is there.
Correct. Therefore, other account.
One account is nil on this 27. Here, my lord, may I be permitted to pay order dated 25/11/2019, annexed by my friend, 53, DRT order. There, just operating part, I am just reading out, 53 page. Last 53 says, for the applicant, liberty to.
That is the liberty to offer OTS.
No, OTS way. I will demand, and he, on our demand, he is permitted to file the OTS. So I demand on 27.
That will not take anybody's case even one inch further. But he is saying,
Based upon my demand, we have offered a OTS appraisal to consider, and
we do not call that. We want to know
right.
what was the amount due as on the auction money was paid to the bank by the bidder, highest bidder. What was the amount?
That I may be about some.
So in similar in matters like this, you have to keep one officer behind you so that he will assist you.
My lord, what is happening with due respect? When either promotion or for some other reason, frequently changing. The person who is coming, they have coming to me, I have 10 times, because it's a long period, 10 times I have to make them understand. Because the old man, the new person, he doesn't know anything. And
If
time and
will permit me, if the order that was under review, that was passed on the premises that whether the DRT has power to condone delay or not. My lord, I may be permitted to rely on a judgment of the Supreme Apex Court recently married 2026. But the Apex Court has
No power to condone.
My lord, no power. Even this Hon'Ble Apex Court held that the DRT provisions of the Act of Limitation Act does not extend to the tribunal.
Section 5 is not applicable.
From section 4 to 24.
All they are excluded.
All one. My lord, I may permitted to.
Even 14 is also excluded.
My lord, but the judgment I am pressing into surface.
14 of Limitation Act is also excluded.
They will describe my lord, so last paragraph. 2026 live law. Let's say glance to the internal page.
Latest judgment.
My lord.
Which paragraph?
Paragraph G, my lord, page 40 of the internal.
40.
40. Last for 2 pages. The subclause, subpara 3, Roman 3 is relevant for the case. 3 and 4, I, 3I and IB.
Three.
Roman.
That was 1963 Act,
Limitation.
but not seven. Limitation like this. 4 to 24. Even time procured for securing the order copy is also not discountable.
That's what it is.
Applications of no, it applies.
It only when permitted by the act.
That lay down a prescribed period limitation as well as
They apply to suits.
Only apply to suits, application of applications which are made under any to courts and not to those who made in courts.
But this judgment did not consider section 70.
No, it was in respect of the
DRTA.
The judgment on respect of ancient matters, my lord. But here it said that it does not apply to tribunals and quasi-judicial.
But
the tribunal DRT also coming in.
But there is one more judgment of apex court that arose under the 2013 Land Acquisition Act, Right to Compensation Act. There apex court said, in identical terms, we held in Harvard bench that maximum period of delay that could be condoned was 45 days. And where the delay was beyond that, we had dismissed the writ appeals. Matter went to Supreme Court. The Honorable Supreme Court held the provisions of Limitation Act are applicable. Identical questions.
Applicable to, because the order was passed by the bench of the High Court. But here it is the order passed by the tribunal. And the so-called copy is concerned.
There the appeal was by the
Land Acquisition Tribunal.
The reference of 18 of the old Act, 1894 Act. Reference for enhancement of compensation.
And so that.
Social benefit oriented statute. That is the kind of social Consumer Protection Act. Social benefit oriented statute.
Consumer Protection Act, the judgment is also there that the period for filing written statement cannot be extended by the. So, that this special statute, unless it is so permitted.
And 17 does not borrow provisions of Limitation Act at all. The tribunal, now we have held that way. The order which is now put in review, we say beyond the prescribed period, the tribunal cannot condone the delay.
That your lordship has said.
Then where is the?
That your lordship.
Then where is the way to go to the other aspect?
That your lordship said. Let me place that question. Your lordship may see paragraph 4.1 at page 61. Yes.
3.
The outstanding debt is not in dispute. The subject property has been mortgaged in favor of the lender bank for securing repayment of debt, which is about 60 lakhs only. After adjusting the auction proceeds of the security property, the e-auction was scheduled by notice dated 24/8/2018 in terms of section 13(4) of the Act, read with such and such. The essay such and such was filed by the borrower on 17/12/19, laying a challenge to the coercive proceeding. The period of limitation prescribed under Section 17 of the Act is 45 days. Arithmetically, there was a long delay of 418 days in filing the said essay. Therefore, the same was rightly rejected by the DRT by order dated such and such, since delay application in IA number itself was rejected by the very same order. This view gains support from Karnataka the High Court decision in such and such. It is relevant to mention here what the apex court observed in union of such and such. It is that portion your lordship has quoted. It is not essential for special or local law to in terms exclude the provisions of the Limitation Act. It is sufficient if on a consideration of the language of its provision relating to limitation, the intention to exclude can be necessarily implied. As has been held in Hukum Narayan Yadav versus Lalit Narayan Mishra. If on examination of the relevant provision it is clear that the provisions of the Limitation Act are necessarily excluded, then benefits conferred therein cannot be called in aid to supplement the provisions of the Act. Thus, where the legislature prescribed a special limitation for the purpose of an appeal, and the period of limitation 60 days was to be computed after taking the aid of Section 4, 5, and 12 of the Limitation Act. The specific inclusion of this section meant that to that extent only to provisions of the Limitation Act stood excluded, and the applicability of the other provisions be necessary implications stood excluded. Since essay was filed after broking a long delay of 418 days, the application in IS such and such has been filed on such and such itself. The date on which essay was filed, subsequently IA number 492 of 23 was filed for the same purpose. The former application was rejected as not placed, whereas the later application is dismissed on merits and maintainability. Thus, DRT, by order dated 29/2/24, there is reason and logistic in version of DRT. Firstly, Section 17 of the Act prescribed a period of 45 days to approach DRT for laying a challenge to coercive recovery proceeding. The same reads under. Your Lordship has quoted that provision. Secondly, the Parliament in its wisdom has not provided for condonation of delay at any length, regardless to the possibility of explanation, possibility of explanation offered for the same. It is a matter of legislative policy, and therefore the impugned order of DRT, which ignores the same, is liable to be set aside as being on without jurisdiction. This was your Lordship's finding, and your Lordship said allowed the writ petition.
Now with the review.
No, writ petition was allowed. So against that, I have come up in review that notice was sent. I do not
assuming that you had appealed.
Yes.
How you will make alteration to the legal position?
Now question is, if the money would have been adjusted.
No, question is to enter into that merit. There
was a delay, my lord. I cannot say that no. I cannot say that no, there was no delay. There was a delay. There was a delay. And delay, my lord, I have tried to explain. Now question is, your Lordship subsequently also came to another finding. Learned counsel for the petition is right in telling us that the public auction is of 2018 and his client has already remitted huge sum of such and such. Learned panel counsel for the lender bank points out that borrower is unscrupulous by any standard, since he has been dodging the recovery proceedings with one or other excuse thereafter. He does not deserve any remedy, even on mercy ground. By when conduct of the parties are such and such, your Lordship said and proceeded with the saying that he is liable to get. My lord, my only point before your Lordship is that as on date, two accounts were there.
Next one. This review petition seeks the recall of our judgment dated 10/2/2026, whereby OP auctioners WPC number 1124 of 2025 was allowed, and the order of the DRAT negativing the appeal filed under Section 17 of Surface Act 2002 was affirmed, essentially on the ground that when the Parliament has enacted a limitation clause in Section 17 and also a clause for condonation of delay of a particular period, beyond that period, delay cannot be condoned at all. First of all, the judgment is also structured on the ground of culpable conduct of the review petitioner who had remained unrepresented despite service of court notice, admittedly. First of all. Next platform. Learned counsel Mr. Bose, in his inimitable style of persuasion, submits that merits of the matter weigh in favor of his client, in as much as the account in question was shown to be nil liability because of appropriation of remainder of the auction money to the said account. That aspect having not been considered by the court, there is error apparent on the face of the record for invoking the provisions of Order 47, Rules 1 and 2 of CP 1908 or the law akin to that, which would eminently warrant interference of this court. Next paragraph. Having heard learned counsel for the party and having perused the petition papers, we decline indulgence in the matter in as much as we have construed the clause for condonation of delay enacted in Section 17 of 2002 Act as excluding the provisions of inter alia Section 5 of the Limitation Act 1963, and therefore the appeal filed before the DRAT being time barred, no, DRT order being said. The appeal filed before essay filed before the DRT, essay in diary number, essay diary number
2519 of 19.
2519 of 2019, being hopelessly barred by time and being beyond the condonable limit of delay, was rightly dismissed. First of all. Next paragraph. Learned counsel appearing for the auction buyer is justified in banking upon latest decision of the apex court in in civil appeal number, no, in 2026 live law SC 19 between the Property Company Private Limited versus Rohingya Dagi Mazda, wherein At paragraph 140, 160, it has been observed as under clause 3.
3 and 4.
3 and 4. So small. In the above circumstances, despite vociferous submissions made by learned counsel appearing for the review petitioner, there is absolutely no explanation whatsoever offered by him for not honoring the court notice and for not coming before the court for participation in the proceedings. First off, already we have recorded a finding as to the culpable conduct of the petition, the review petition, in the judgment now put in review at our hand. First off, counsel very fairly admits that his client happens to be a businessman who has been in the field since last more than 15 years. First off, it is not that a member of oppressed classes or a peasant or a pagan or a person hailing from rural area is before us. First off, one who does not who shows scant respect to the court notices, cannot be permitted to invoke review jurisdiction in matters like this. First, in the above circumstances, the review petition being devoid of merits is liable to be rejected, and accordingly it is.
One thing, by order dated.
What happened to that rupees 10 lakh?
10 lakhs, it is deposited in bank.
In bank, it is deposited. You appropriate that money to the account.
But so far as the order under review, let's be directed for
the amount deposited pursuant to interim order of this court by the review petitioner shall be appropriated to the outstanding amounts in the,
If any,
outstanding amount, if any.
Now the sale proceeds has crossed the limit also,
In the,
as per their own statement.
First off, if there is any remainder,
assessment.
that is, the same shall be remitted back to the review petitioner without broking any deal.
My lord has directed specifically to hand over question and also please to direct to the concerned police station.
Mangalore police station.
That may be
Because
Now it is dismissed, na?
2 months time was given.
2 months time.
Now
The lordship granted initially 8 weeks time on the date of judgment. Thereafter, after review, lordship state protected me, subject to I depositing 10 lakhs. This is what is.
Now you give possession tomorrow.
Overnight, can a house be shifted, my lord? I leave it to lordships.
How much time should be given?
My lord, I leave
No,
it to
you
lordships.
tell it. You don't leave anything to us. Neither we are lenders nor the witnesses, the persons who are guaranteed.
But one thing, man, to unsettle a house, I'm not fighting this as a, to unsettle a house. Your lordship had granted 8 weeks. After that, your lordship, after seeing that, your lordship granted me the interim order, and I have complied, and which I should comply, because once an order is passed by the court, has to be complied. My lord, I leave it open for your lordship.
you give another 8 weeks. But subject to the condition that you should on your own peaceably deliver back the possession.
Whatever is there in your lordship's original order, that will be there because now my review is gone.
Passionate submission of learned counsel appearing for the petitioner, review petitioner, comma. A further period of 8 weeks to be reckoned from this day is accorded to him for vacating the premises peaceably and deliver its possession to the auction buyer with the mediation of bank. Failing which the jurisdictional police, by using reasonable force, shall remove the petitioner and all his articles from the premises by adopting a normative process. First, in such an event, it is desirable to videograph entire exercise so that there shall be no scope for making false allegations against anyone by anyone. Okay. If the petitioner fails to deliver the possession of the property as directed after the period, comma, the jurisdictional police can arrest and detain him to facilitate the taking possession of the property.
Well, this will never happen. This was an order previously. I have read your lordship.
If it does not happen, don't do it. Because we have been seeing people. Now people do not understand only the simple language. We have to put some cobra inside the order. Yes.
Yes, Lord. So I am ready to pay my loan amount of 50%. Excess.
You have paid the amount? 50% you have paid now?
Sir.
No, that was the order, interim order.
Sir, no, sir, no. Within 4 weeks, sir.
Outstanding amount.
Sir, 84 lakhs, 99.
Outstanding was 84 lakhs, sir. You have paid?
So payment query, no, sir. I am query, sir.
So you have not paid.
No, sir.
Then direction was to pay. Subject to that only.
No, you only has undertaken. 50% you have not paid.
No, sir.
But then what can be done?
Sir, 40 saptah time now, sir.
4 weeks again.
At least some amount you should have paid. Then you should have come before the court. I am a bona fide borrower. I have made some payment. Show us the muscles. Not even a rupee is paid. None.
So Monday.
None. Challenged by the petitioner borrower is to the proceedings of recovery of loans outstanding. First of all, we, by order dated 22/6/2026, had placed on record the undertaking given by the petitioner for making payment of 50% of the outstanding amount, which would include the personal loan as well. First of all, paragraphs 2 and 3 of the said order read as next paragraph. Not even a rupee is paid in terms of the undertaking given to the court while granting lien to the borrower. First, there is no explanation whatsoever for not complying with the order of the court, which was subject to the condition of making the payment. So first, in the above circumstances, the petition is dismissed. It is open to the bank to proceed against the petitioner or his property in accordance with law. Registry to send a copy of this order to anybody for the bank. Copy of this order by speed post to the OP bank. How many? How many parties? Yes, next.
May I please, Your Lordship? Pursuant to Your Lordship's direction, I have prepared the bank draft of 20 lakhs on dated Lordship, that is 35/2026, and went to the registry of the DRT, Your Lordship. He refused to accept, reason being the draft has been prepared in the name of the registered PO DRT. He said that I don't have any separate account which I
you deposit here in the registry.
Yes, I will. The two draft I have already prepared. I will deposit that 30 lakhs in the, because the rate petition already disposed of by Your Lordship, directing the petitioner to approach the recovery officer, depositing 30 lakhs in 3 equal installment. I have made a draft of 20 lakhs on 30, Your Lordship, 35/2026 and 12/6/2026, 10 lakhs. Total 30 lakhs I have already prepared the draft. But the PODRT, the register is refused to accept, reason being they have no separate account. It will go to the finance department's treasury accounts. For that reason, neither the bank nor the petition.
Any application you have filed now?
Yes, I have filed an IA before Your Lordship to modification of that order, Your Lordship.
Who appears for the bank?
Bank, Your Lordship, nobody appears.
They don't want money at all.
Reasoning. Last occasion they have appeared, Mr. P.K. Mishra appeared through virtual mode before Your Lordship. Today they have not there, Your Lordship. May I submit one thing, Your Lordship? I will prepare the draft in the name of the bank, and it should be deposited in a lien account, no lien account. If I succeed in the interim application filed before the recovery officer, then the money has to go to the bank account. And the auction purchaser also filed a petition before the recovery officer to resile out from the auction. He don't want to proceed further. That is also, Your Lordship, reflected in the order also.
That application has been filed.
Yes, Your Lordship. That is page 11. I given the order. We are told by learned counsel appearing for the auction buyer that his client is no longer interested in taking the property, and therefore the money which he has deposited should be refunded to him with interest. He also adds that an application in this regard is kept pending before the DRT. That is before the recovery officer.
What is the amount due?
Amount due, Your Lordship, that is on application, Your Lordship, that is 31,60,771, 29/11/2029, 2019. The order has been. That is Annex 3 into the rate petition.
31,60,771.
The
as on
Your Lordship.
14/11/2019.
Yes, Your Lordship.
7 years are over now.
Yes.
6.5 years are over.
Yes, that is there. So I before Your Lordship that there is a warrant of arrest against the present petitioners. For that reason, I file an IA before the recovery officer to recall the arrest of warrant, which has not been taken by the recovery officer. For that reason, I approve this honorable court, and after thorough hearing, Your Lordship is directed pay 30 lakhs with 3 equal weekly installment, and I have make the draft and approach the.
Now, how much it will be? Now, 31,60,000.
Yes, Your Lord.
With interest record from 1/12/2019.
Yes.
How much it will be? What's the rate of interest? Business loan?
Business.
Then it will be very high rate, na?
Yeah.
This writ petition was disposed of by the order dated so and so, directing the petitioner to deposit a sum of rupees 30 lakh with the registry of the DRT within particular period. First one. Counsel for the petitioner applicant waiving the original bank drafts. No, just to show it, you are showing. Submits that when the same were tendered, registry of the DRT declined to receive the same, accept the same, quoting some difficulty. First of all, he further submits that he may be permitted to credit the said amount, deposit the said amount in an escrow account of the lender bank within 1 week. 1 week.
Lordship, can it be 10 days, your Lordship? 10 days, can it be? Yes, I have the money.
Or this is a photocopy only?
No, this is the original one.
No. Within 1 week. Subject to outcome of essay.
No, subject to the interim application, your Lordship, that is pending before the.
Subject to outcome of the interim application pending on the file of Cuttack DRT.
RC number 97 of 2008, Cuttack, recovery officers.
Pending on the file of recovery officer.
Recovery officer.
Recovery officer of DRT.
DRT.
Cuttack DRT.
Cuttack DRT.
DRT. First one. Ordered accordingly. We agree with this submission. Okay. Ordered accordingly and application is disposed of. Okay.
In the order of the stay of warrant is as it is, your Lordship. The rest part of the order of the.
If that payment, if that deposit is accordingly made, the arrest warrant shall not be executed against the petitioner.
Well, I think the escrow account doesn't bear any interest.
Therefore, but that is the reason.
So no lien
you
interest.
should correct what he says is correct now.
Yes.
You will lose 30 lakhs city. You will lose the interest also.
You want that?
Okay, no lien account will bear interest. Escrow doesn't bear interest.
No lien. No lien.
No liens.
No lien. No
lien.
Okay.
Thank you. Grateful.
Any urgent matters?
Item number, my lord, 31 may be called on 6th of July because it will take some time, my lord.
6th of
31.
Same is also 32. 32.
30.